Well, item number 9. Can it be taken up on Monday?
9. Order 41.
What?
All right, Monday.
Get.
File what?
My lord, I am leading him. My lord, we are praying for leave to file an appeal assailing an order passed by Honorable Justice Bishwajit Basu. My lord, the order was pronounced on 17th. We have applied for certified copy on the same date. My lord, kindly grant us leave to file it without certified copy, my lord.
No, Justice Basu in the principal bench.
No, my lord, that was a circuit bench matter assigned to Justice Basu. Initially, Justice Basu got it parted. After that, Justice Basu released it. Then, my lord, the matter was assigned to Justice Basu, but this was being heard under the heading circuit bench at Jalpaiguri from video conference from principal bench.
17th order was passed.
My lord.
Leave granted.
And my lord, the service of 313 teachers have been terminated. So, my lord, there is some urgency. May I beseech my lord to kindly place it on Tuesday, my lord? We will serve all the parties in between, my lord. Kindly.
Yes.
My lord, we beg
Grateful,
to
my
my
lord.
lord on the same prayer, my lord.
Where is the other matter? Same matter. You are the teachers who have been terminated. And you people? Yes, leave granted.
My lord, grateful, my lord. My lord, we are, my lord, I am also, my lord, praying for a leave. My lord, on the same matter, we are the, my lord, unfortunate one of, my lord, amongst the 313 teachers who went to, my lord, coming up with the same prayer.
We have given the leave.
Oh, grateful, my lord, grateful, my lord.
The second matter which I have.
Are you sure?
Grateful, my lord. Grateful.
Grateful, my lord.
Yes, call.
Item number 1 and 2. You have please your words. I'm pressing can. No. You started on as per your direction. I have served a copy on Mr.
Have received.
Oh, that
This is legal matter and somehow the 131 days that delay. If your lordship may kindly control that. The report delay has mentioned that page 3 from paragraph number 5.
Judgment was passed when? When was the judgment daily?
Lordship. 9th day of December 2022.
9th December 2022.
Lordship. But I have received for my appointment letter and to take steps in this matter on 14/5/2020. That is the main reason of the day.
It's a legal aid matter in the trial court also.
That I don't know, Lordship. I didn't find anything that kind of such. I filed
How long you are in custody?
throughout.
No, 2020. That means after sentence, about 3 years.
Yes.
No, before the trial judge, it was contested by any advocate.
us. But I don't know it was a legal aid matter or not.
Judgment.
They can make sure.
And accused does not totally benefit by preferring an affidavit related to, because it is he who has suffered, not the opposite party, unlike civil cases. In criminal matters, an accused who has already undergone that sentence does not benefit by preferring the appeal. So there is no question of his negligence or the malafide. But in civil cases, sometimes appellant may get benefit by preferring appellant. So different view has to be given us. Moreover, this is the legal aid. Yes, what do you say?
Regarding the limitation, will not be the discretion of my lord.
We'll record your objection or consent.
Objection.
Yes, record an order.
Regarding.
Learned advocate for the petitioner and learned advocate for the opposite party state of West Bengal are present. The application under section 5 of the Limitation Act is taken up for consideration. Heard learned advocate for the appellant and learned advocate for the opposite party state of West Bengal. Peruse the petition file and materials on record. Stop. The criminal case under section 6 of Protection of Children from Sexual Offences Act 2012 was instituted against the appellant in the year 2020. Yes, which year, which date?
It was for the legal service operation of political education.
Number. 5th February 2020.
5th February 2020. The appellant petitioner is in custody from the said period and thus he is in detention for more than 5 years. Stop. Pursuant to the conclusion of the trial, the petitioner has undergone imprisonment of about 3 years. Stop. It is the contention of the appellant petitioner that this is a legal aid matter and as per the procedure, he was engaged. And the learned advocate was engaged by the High Court Legal Service Committee, High Court Legal Service Committee on 14/5/2024. Thus, there is no laches on the part of the appellant petitioner. Stop. Upon considering the submission of the learned advocate for the petitioner and the grounds furnished, we are of the view that the appellant petitioner has furnished sufficient cause for the delay in preferring this appeal. And as the delay is neither deliberate and willful by the appellant, non-malafide. Moreover, an accused who has suffered imprisonment
the delay which has occurred cannot be totally attributed to
yes, thus the delay which is occurred cannot be totally attributed to the petitioner appellant. Thus, this delay in preferring this appeal is condoned.
One inquiry, but
What is that?
And upon hearing the learned advocate, this appeal is admitted.
in the trial court also, there was a lawyer from the legal aid.
trial could
Yes,
also
yes,
be-
my lord, because as per the order on the last question, my lord will find, as per the order of the Honorable Justice Jamal Bakchi in CRA in 2014, my lord, there was an order in for each of these accused persons when they are convicted. For the convict, appeal has to be preferred within the limitation period and district legal service authority has to be informed. They have to take steps for this.
Hmm.
It's in the order, my lord.
Which order?
It's in the judgment also.
Where
To
you-
the
Judgment of the trial.
Attached to the appeal. Last.
The order. Fourth paragraph, however, starts from however, in compliance.
Oh, very good.
My lords.
Two appeal. What is the other one? Tagged matter?
That is filed by the jail
Oh,
authority. sir.
দুটোতে।
That is jail suspension.
No, no, whatever.
That is by the appellant accused through legal service authority. The other is from the jail authority.
Jail authority.
So both the appeal, দুটো appeal admit করেছো?
It has to be tagged together.
No, ওইটাতে তো কোনো application in the jail appeal there is no application for
No,
condemnation.
nothing. It's generally like this only. They send the appeal with all the documents. Then it will be referred to the legal authority, legal service authority, then they appoint us.
No, very good, but who filed the other CRA? Jail authorities have not.
Jail authority, by
That
a
is-
letter itself. It will be registered at CRDP and then it will be tagged with the matter from the legal authority and then heard by
So
us.
both the appeals are to be heard together.
Together, Lordship.
1 and 2.
One and two.
One is CRA D15, other is CRA DB 54.
The first one is from jail authority.
হ্যাঁ হ্যাঁ
Oh.
ওটা একটা jail ধরেছে।
I have filed that 54 of 2025.
54 is of the jail authority.
No, no, no. 15 is from jail authority.
So in the 15 jail appeal, there is no connected condonation
No,
application
no,
required.
nothing. It was maybe in time also, but
Wow.
sometimes it is not hard together.
No, no,
Lordship,
we-
my senior will assist better.
this jail appeal, we understand the first appeal is by the victim. 54. For that, we have allowed the session. So far as the jail appeal is concerned, that is also delayed
Jail, we don't know when it has been filed.
of 2024.
22 is the sent order.
So what happens?
No, our query is for the jail appeal, no
Application.
condonation application is required.
Nothing,
Only
they
an
only
application.
send an application and do their job.
Then how can we admit that, though we have admitted this, we can.
Actually, that becomes now infractuous, that's because the same matter, 54 has been admitted. So it is the same, CRF 15 will be just that.
That is the jail, but what is the procedural law about that? Suppose a jail appeal,
What happened?
jail appeal is filed through an advocate.
No, that is the problem.
By the authority.
The authority, they just send a application.
And
That
that
is
is
the-
registered, and that is registered
That
as,
is- there is-
so where is that application? It must be in the file.
Maybe,
We have a-
we don't-
Because you see, in those type of appeals, probably the grounds are not given.
Nothing given, nothing. given.
Only
So
simple
we
let-
have to make it prepare and file once again. That's
Yes,
the
yes.
problem.
That is, they will come file before
They
the
have
court
a- They have a format.
and it will be sent to the legal service authority.
Same thing. With the vocalatma.
কি by legal service jail থেকে? Oh, that means vokalatnama is there. Oh, vokalatnama is there.
কিন্তু সেটাতে তো ডিলে হচ্ছে, তাহলে তো উকিলকে ফাইল করতে হবে সেটা।
মানে ডিএল অ্যাপিলে আলাদা ভাবে কিন্তু এই সিআই আসতো না, সিআই নাম্বার করতো না, এমন নতুন নিয়ম কি হয়েছে জানি না।
আপনি
না না ক্যালকাটা হাইকোর্টে তো অনেকদিন থেকে জেল আপিলে প্রভিশন আছে।
একটা rider দিয়ে দিন, challenging the same judgment, jail authorities also prefer to appeal, being such and such.
As the original appeal is.
No, accordingly, we engage such and such in the jail appeal also, and both the appeals will be heard together.
Yes,
We are engaging you in the jail appeal also.
Grateful.
yes.
And we say that both the appeals will be heard together.
আচ্ছা ওটা তাহলে লিখে নিন একটু। As another appeal being CRA DB 15 of 2024 being the jail appeal is also preferred. We, yes, by the jail authorities, we engage Mr. Ganguly along with Mr. Abhishek Sarkar to conduct this appeal on behalf of the appellant.
And my appointment will be regularized, my lord.
And
But
the appointment of Mr.
Niloy Chakraborty.
Niloy Chakraborty on behalf of the state of West Bengal be also regularized. Let the both the
Then Niloy Chakraborty APP shall also appear in this matter.
yes, and Mr. Chakraborty shall also appear in both the appeals, which are to be heard together.
Both the appeals are দরকার নেই এটা ওটাতে তুমি আছে you are already
They are
engaged
already
na?
engaged, even then 1 and 2, same order will be passed, my lord. It will be a
It will be a composite
composite order.
Composite
So
order.
let it be there in both the matters.
তাহলে ওটা লিখে লাস্ট লাইনটা কি লিখেছো না না মিস্টার গাঙ্গুলি উইথ হিজ জুনিয়র শ্যাল কন্ডাক্ট বলেছো তো
Another appeal being held, being the jail appeal is also preferred by the jail authorities. From
has also been preferred ইসটা না বলে has also been preferred
We engage Mr. Ganguly along with Mr. Sarkar to conduct the order of the above. And Mr. Chakraborty.
and Mr. Chakraborty
And-
APP would appear for the state
of West Bengal.
state of West Bengal.
Niloy Chakraborty.
So both the appointments should be regularized. So
both the appeal admit করে
in effect, both the appeals are admitted.
issue formal notice ওই যেটা আছে দিয়ে দেবে admitted issue formal notice and we would be at liberty to
The appellant is that will be at liberty to file application for bail.
any fine imposed
No, no.
No, fine.
Stay.
realization of fund
The realization of fine as directed by the learned trial court shall remain state till further orders. Yes, till further orders.
আরেকটা ওরা এবার নোটিশ দিয়ে সার্ভ করো সেটাই তো বেলের
আরেকটা 1 নম্বর সেটা
ওইটাই যেরকম আছে সেরকমই থাকবে ওরা তো ফাইল করে দিয়েছে
Bail application. Okay, then no question of granting liberty to file that bail application. Let that bail application be listed. The bail application be listed on Monday. Oh, next circuit, yes, bail application be listed.
Copy has to be served. Copy has to be served.
তুমি বলে দেবে একটা যে an application being such and such filed by the appellant praying for bail in
Bail.
connection with the appeal
Be listed in the next circuit.
has already been filed. Let a copy of the same be served upon Mr. Chakraborty. List the application for bail. The next, list the matter, list the application for bail in connection with appeal
In the next circuit.
before the next circuit, before the next available circuit bench. Give a copy to Mr. Chakraborty. You have given?
Yes.
Yes. Next.
Next was a similar matter, similar type of problem. Kindly sees this order.
কি বলছো? Section 5 টা allowed? আপনি একটু দেখুন Yes. Item
Item
number.
3 Lordship, kindly sees this order.
You ordered this.
Not sure I have only one copy. I apologize.
Dilen?
Then division bench appointed me, and as per the same, the registered issued notice to me. Lordship, it has been filed. Now, my humble submission, Lordship, if the appointment of Mr. Sarkar is also because I do it pro bono, so the expenditure he can bear this thing. I don't even charge.
No, why it has come up before us?
It is there in item number 3, Lordship.
Why? No application has been filed.
Application has been filed, Lordship.
It has been.
Appeal has been filed, but
Application for delay.
delay has not been filed.
So file that application for delay.
Lordship, for that, we really need some time because we have to inform the concerned legal service authority of said district. They will appoint a legal person, the paralegal officer. She or he will come. There is a lot of days are required.
No, why I'm telling Lordship, kindly appreciate, for the affidavit has to be done. Now, person is in jail.
No, affidavit is not done by the accused person, by some other person.
But in many of the cases we see, especially regarding legal aid matters, They are so poor and so negligent regarding the same. When they are in custody, their family members do not even contact. So they have to contact the legal authority, appoint a person from the government, district, and bring him here and then.
Yes, earlier, other than those cases, by the Tadbir Karats.
Tadbir. There is no Tadbir case because there is jail appeal.
And appeal we can file because appeal doesn't require the affidavit. That's why we can file it early. In last case also, it was filed in September. But last
This is the
Monday
problem
only
with it.
What is the allegation?
In this.
Murder.
302 murder.
No, if it is to be filed, it can be filed through a Tadbir Kar.
No, we have already filed the appeal because appeal.
Appeal, all right.
So who will be the Tadbir Kar? Because we cannot appoint any person.
Delay of how many days?
Rashid, a lot in this case also. And we have to file the formal application, otherwise.
So take steps and file it in the next circuit.
Rashid, but tag the both the.
We have prepared the same, but now the question is the district concerned authority, they will appoint some person and he has to come to High Court and then execute the affidavit. So these are the problem we are having. Because the family members, they do not bother even.
It is CRA division means 37.
Lordship.
Why it is not telling?
That was filed by the jail authority.
The same what happened in earlier case.
And
They filed one page application.
But that is not before us.
No,
Today
not
it
yet.
is not before.
Not yet.
But we have filed this CRADB 68, which is relating to the same matter. Only one page application comes from the jail. No ground, nothing. No document even.
Only the order.
We will not comment about that.
No,
We
no,
will
no.
say in this matter you are engaged along with a junior of your choice and you would take appropriate steps for filing application. সেটাই বলো।
Because the actual scenario I am expressing. This is
Mr. Ganguly, along with his junior, Mr. Abhishek Sarkar is present in court on behalf of the appellant appointed by the
only me, Lordship, his appointment.
না এইটাতে তো ওনাকে অ্যাপয়েন্ট করে।
Okay. Is present on behalf of the appellant. Yes, the
না, এরকম বলুন, in the jail, we have been informed that in the jail appeal, a coordinate bench in the jail appeal against the judgment impugned in the present appeal, Mr. Ganguly has been appointed. In view thereof, in the present appeal also, we engage with Mr. Sajansas and their appointment be regular.
it appears from record that Mr. Ganguly
That in the jail.
and that in CRADB 37 of 2024, which is a jail appeal, Mr. Ganguly is already appointed to represent the appellant. Stop. However, in this appeal also, Mr. Ganguly is along with his junior. In view thereof, Mr. Ganguly, along with his junior, Mr. Abhishek Sarkar, is appointed on behalf of the appellant to represent this case. In CRA DB 68 of 2025.
Let such engagement.
The let such engagement of Mr. Ganguly as well as Mr. Sarkar be regularized. Let steps be taken.
No, Mr. Ganguly.
Yes, Mr. Ganguly prays for time to take necessary steps to file application for condonation of delay. Such prayer is allowed. Let necessary steps be taken and the matter be mentioned before the next available circuit bench.
That is also filed. So
Acha, in this we can engage him
Yeah,
also.
yes.
We also engage.
It is how, as Mr. Niloy Chakraborty is present in this court assisting us,
As Mr.
Niloy Chakraborty is present in court.
We
We also engage Mr. Niloy Chakraborty on behalf of opposite party state of West Bengal.
Chakraborty with a junior of his choice.
With his junior, given the name of your junior?
With a junior of his choice.
With a junior of his choice,
Let such engagement.
let our engagement be also regularized.
And both the matters that.
It is clarified that both these appeals will be heard together.
I think number 5.
I'm praying if the matter could be taken up on Tuesday, Manoj.
Why?
Manoj, Mr. Ghosh is Manoj appearing in this matter, Manoj. He is out of station, Manoj. Mr. Vikramaditya Ghosh.
Let us see what is the. Now, unnecessarily matters are being. যেগুলোকে একটু শুনানির সময় লাগে
What's the interim order? Bail application.
জীবনে মামলা শেষ হবে। You have annexed the order in your stay application?
Yes, Manoj.
Order 41 rule 12.
No, no.
এখানে এই যে adducing additional document.
Application fail করেছে।
Adding some other additional document.
Mandam আছে। What are the two applications?
Manoj, one is for stay and another is Manoj for Manoj. We are praying for
You are the writ petitioner appellant.
writ petition appellate. Can two, Manoj, is a prayer for addition of documents, Manoj.
So your writ petition was dismissed.
Dismissed, Manoj.
So where is the scope of any stay?
What is the wrong in the order?
Manoj,
It is, you wanted correction of record of right?
yes, Manoj, but the endorsement, Manoj, actually this is the third round of litigation. That was the third round of litigation, Manoj. The endorsement was made, Manoj, in Manoj, that was a complete high-handedness, Manoj, on the part of the authorities, Manoj.
Now, why it is being sent to the land commissioner? Read the order, list the
Manoj,
order.
I'm very of the brief, Manoj, actually.
Why, sir, you people are not ready? You are a junior, you getting an opportunity to argue. We are not dismissing your appeal. What more favor you want? You are bringing for it. What more assistance you want, sir? You have to study the brief and come over. You would be the future.
Manoj.
If we dismiss the appeal, then we can call for your senior. But if we hold in your favor, what is the problem? Now tell us why the, please come to the order, take our copy. Eke dao.
I can share my.
Sure. So the point was raised as regards maintainability. Take the order of 7th of April. Which order do you have assailed?
Trial-
7th
trial-
Manoj, we have assailed, Manoj, order
26/11.
26/11.
Trial court order.
26/11.
Yes, Manoj.
এটা আপনার
না না এই তো মেমো ওটা আমার মেমোতেই পেয়ে যাবেন তো
এটা মেমো না
মেমোটা কোথায় মেমোর থেকে তো
কি লিখেছেন
আচ্ছা লাস্টে গিয়ে রেকর্ড অফ রাইটস কারেকশনের জন্য লিবার্টি দিয়ে গেলাম
দিয়ে পড়ি So prayer was refused since it was recorded as a retained land in
Yes,
favor
madam.
of Bagdogra TS.
Yes, ma'am.
This was the dispute. You
Yes.
say that no, you are
Initially,
the
there was
owner.
no such.
It
my
is
lords,
not a
endorsement.
retained land. You are
Yes,
the
my lords.
owner and the name should be transferred.
My lords,
My
kindly, my
name
lords,
should
once
be.
my lords takes the can two, my lords, the application, my lords, I have filed. My lords, they have issued, my lords,
That is your
communication.
application for additional
Yes,
evidence.
that was considered, my lords.
Considered.
That was considered, my lords, not taken into record, my lords, considered but not appreciated, my lords. In the
Can-
light of the subject
can
matter of
two.
the writ, can two.
What is
Can two
it?
page 9, my lords.
Can no can be. Stay application.
It's can 1, my lords.
Uh, No, it
Page
is
number
can
9.
2. Stay application is can 2.
My lords, can 1, my lords.
Abar bole 1.
Stay application is can 2, my lords. I am, my lords, referring to
Stay
can
is
1.
can 2.
Yes, my lords. Stay
You are
can-
referring to
can
can
one.
1.
For adducing additional document.
Additional document.
Page.
Page 9. Page 9, my lords, bottom of the page, my lords, third paragraph, my lords.
What is page 9?
My lords, this is, my lords, the
Application of the company for correction.
My lords, what they have disclosed, my lords, bottom of the
Paragraph?
page, my lords, paragraph 3, bottom of the page. Scrutiny of the RS record reveals that these plots were recorded under RS Khatian 10 and 24/6. RS Khatian number 10 recorded in favor of Punai Urao, my lords, who is the father of the writ petitioner, being RS plot number 1, 2, and 3 with an area of such and such, my lords, and 6.83 acres respectively, my lords. They themselves, my lords, have disclosed this stand.
No, this is a different tea garden. Here it is Bagdogra.
No, my lords, but with regard to the plot numbers, my lords,
Just a moment. This order was of 26 November 2025. Subsequent to that, this
subsequent
memo
development,
came.
my lords. Yes, my lords.
So in the previous order, it was manager Bagdogra Tea Garden. Bagdogra Tea Garden, evident from all that the land is a lease land in favor of Bagdogra Tea Garden under section 6(3) of the West Bengal Estate Acquisition Act.
That is their stand, my lords.
That was the stand.
But my
Now, this is not. This is a memo issued by the land commissioner.
Yes, my lords.
Land reform commissioner কি বলছে?
No, these the documents which you are now seeking to rely, that is an application with regard to this particular company,
Yes,
TERIT
but my
company.
lords, with regard to the plot number, my lords, what they have given, what they have, my lords.
That's very good. But the order by the writ court order,
Yes, my lords.
he has said writ petition is
This was not appreciated, my lords. This document was not.
what he has writ petition has been disposed of. It has not been dismissed.
Disposed of.
Liberty has been granted to you to approach the appropriate authority.
Yes, my lords.
Now,
But
who is the appropriate
my lords,
authority?
the land tribunal, my lords.
Yeah,
Huh?
correct the land record.
But
Who will be the appropriate authority?
Block land reform,
my lord,
block land and land reform talks. They have to
How
correct-
can BLRO correct
Yes,
it?
because they have to correct the records of right.
We cannot touch it if it's a written land.
It's just
Yes,
a matter of
it-
records on the basis of existing rights.
It-
Documents with regard to rights.
This is land reform talks.
That has
My lords,
only before the-
they themselves have recorded that it's in the name of my father, my lords.
Petitioner-
Page 9. And subsequent to litigations, my lords, they have.
Applied for the permission to transfer the land. The revenue officer asked for her title. She failed to produce because the record of rights stands in the name of the tea garden.
But this memo is diametrically opposite.
My
It
lord,
says that
my
it
lord.
is not a written land.
My lords.
Then who is the authority to decide this issue? Who is the authority? Under chapter 2A, schedule ka who is the authority?
That the land reforms act.
ওর কাছে delegate করে দিলে কি হবে? He will take into consideration.
After and hear the parties.
My lords, may take it up on Tuesday, my lords.
No, what we will do is, we will you come with that insert, you say that we are unnecessarily pending. We will treat this communication and we will ask him to make a formal application along with this that will be considered upon granting an opportunity.
And all parties will be heard.
Let me take it up on Tuesday, my lords.
You come with that instruction. Any delay in filing the
No,
appeal?
my lords.
No, মঙ্গলবার দিনকে রেখে দাও।
I'm grateful.
Rashid, this is a mandamus appeal. Rashid, there is showing some defect in this matter. As I have not filed, able to file the certified copy, I have applied the same. I took the leave from your lordships and then filed that.
How much is the delay?
Nothing delay, immediately next day I filed.
So what is the defect? What
Defect
is-
is certified copy has not been filed.
Yes, that is.
The lordship may kindly,
Have you got the certificate copy?
not yet lordship, here at least a month for a certified copies, minimum requirements. Before 12:30, they are not providing the form even. There is a lot of embargoes. actually.
What, before 12:30?
They are not providing the form even to apply the certified copy.
Who has to provide the form?
The form from the department.
কি ব্যাপার বলছো? হ্যাঁ?
After taking permission from your lordship, that day I went to for filing. They said where the judges are said ki today it has to be filed and get it listed. Give me show that. Then I have to go to register. Register had directed them. Then only they have taken my appeal. This is the scenario in department's lordship.
কে আছে ফাইলিং এ?
Shall we take-
Are you sure this has happened?
I
You are-
me and my clerk
Don't show
proper-
your clerk. You tell us.
I have also gone to the, I went to the register that day.
কে ডিপার্টমেন্টে কে আছে? ডেকে পাঠাও।
That day, I think Abdul was taking care of these matters. They sit at 3:15 and immediately at 4:05, they said, I will not take your brief. I requested the register, then only he has taken.
কি অবস্থা? রেজিস্ট্রারকে বলতে হবে যে এটা immediately ইয়ে করে।
And I generally say these things in court. That's why my files are always treated in a bad manner.
You grant করলে immediately সেটা একটা ফাইল নেই। রেজিস্ট্রারকে দিয়ে একটা স্ট্যান্ডিং অর্ডার করিয়ে দিতে হবে।
When did you take our leave?
16th morning, Lordship. It has been written backside of the main file, Lordship.
Yes, 16.
Lordship,
And when did you ask for enlistment of the order?
17th only, but they are denied.
No, no. Do you have to start copies up on the other side?
Not the appeal, Lordship.
Huh?
Not the appeal.
Yes.
I'm pressing my appeal today only. I'm not pressing my stay petition.
No, no. When you were granted leave on 16th December,
Lordship.
it was allowed to be filed on 16th itself.
Lordship.
Then what is the
It was
problem?
not numbered even. It was numbered at about 6:30, 6 o'clock, 6:30. This is actually tender matter. I didn't have any opportunity. If lordships will go till 5th, I don't have any option to do anything.
Till
5th of January, because till then there will be no court.
this order has been passed when? Oh, this
15th only, lordship. There is some misunderstanding, I think. I'm able to make lordships understand this time.
Without service, how can we hear? Who is your other side?
State of West Bengal.
So you should have
Or you can
served,
serve the
na?
trial court advocate.
I'll go back. I'll serve on them. But if your lordship may given stay till 5 or whatever.
How
the
can
next
it be
day-
done? How can we do that? Without an application,
I-
service.
The application is listed along
Let
with
us
this.
see what is your matter.
Lordship, can I explain the matter in a nutshell?
Just wait.
Lordship.
Work order has already been issued.
No, not yet. That was also missed. Lordship, she is the
Is
trial
there
court
a
order.
private respondent
court
here
Lordship, she is the trial court advocate.
for the state,
For the, not for the state, for respondent number 2,
Pradhan.
Pradhan. Personally, she was appeared.
Have you issued work order? Have you issued work
No.
order?
Not yet. Lordship, that may be specified from this order itself. This person has filed 3 weeks. His three applications were rejected. And this is the 3rd writ. Fortunately, the honorable single bench considered, understand the matter. I am able to make her understand. And Lordship, will kindly see to this order.
This order for in which matter?
3rd matter, 3rd writ. My 2 writs were rejected, 1 is accepted, saying that the work order not yet been issued, and also this is the e-auction, and a notice cannot be published on. Lordship, my apology, I have only single.
This is also an e-auction.
Lordship, the same. There are a lot of words. E-auction.
Give a copy of the stay application, huh?
That is what I am submitting. My
Which petition? This
correct one, which is order I have handed over, Lordship.
No.
Lordship, can I get a?
No, the order under challenge, that is dismissed. That writ petition was dismissed.
Lordship.
Work order has been issued. The court is not in. This is the ground for rejection.
Lordship.
Because work order already issued.
he has not produced the original.
Lordship, shall I submit in a nutshell the story actually?
Yes, what happened?
Lordship, e-auction was published. My stay petition, page number 38, is saying about all the jobs. Mr. Alam has 3 different companies. By one company, he has applied for 2 works. Through one company, he has applied for 3 works. Like this, he has filed 3 sets of work. It was rejected only because stating that his papers are not valid. No, paper has not been produced for verification, physical verification. It was the
give a stay application to her. Come back on Monday.
Today itself. Lordship, can it be
Monday.
Lordship, can I have a stay till Monday at least?
Without service, what can be done? How
I'll
can
do
we
it
help
today
you?
only, within 15
Can you
minutes.
take instruction? কি বলবো? কি বলবি?
Monday আপনি বলেছি don't take any steps. It's not taken. এই তো পঞ্চায়েত অথরিটি তাকে
তোরা স্টেটে
এরা বলছে যে লিজ দেওয়ার পরেও নাকি ডিপার্টমেন্ট ফাইলিং নিচ্ছে না।
যেটা গতকাল যেটা হয়েছে
বন্ধ করো।
when the petition is pending.
2407.
2407.
2407. Yes. A 2406. Is 2406.
06, I'm sorry.
2406. It is dismissed.
So this is a what under the same NIT?
Yes, your
Not
Lordship.
sure.
Same option, because there was a violation of the terms and regulation where the petitioner had not approached or appeared before the answering respondent for
With the original documents,
with the original documents, which was uploaded.
but uploaded with the original document.
Uploaded, but there was a term in the option.
That you have to produce the
Yes, your
original.
Lordship, when and wherever asked for. The notice was published.
That asking.
Wait, sir.
That it was published, but all the other applicants had appeared and their documents were verified.
physical thing.
And the physical verification, but this petitioner had not appeared. This why his application it was rejected. And considering that it is an unofficial substance, the work order which my senior had already raised before the report that why considering that it was an e-option while the notice was a public on the online. Considering that all the applicants are local, because it was that therefore it was published in a notice board of the Panchayat office because they are the answering respondents and they are the option team. It is an unofficial submission and the petition which is still pending and it was station
So
of.
we will fix the time and date. He will go with all originals. You consider then it is.
The warrant has already been.
No, not yet.
No, in regard of this.
Nothing. No, nothing. I deny.
বলেছে তো আমরা ডিসমিলি করবো তাহলে you should let him appear before the prison. No complications could have been Then you give a copy to her, you take instruction and we are keeping it on Monday. If not read good, let's say it has been issued. It is statement they can. Then why it was recorded that word order has been issued, you were there?
It's for the warrant issue.
Not yet, I say.
Because of petition number 2408.
2406. We are concerned with 2406.
None of the work order is issued yet.
This is 2406.
06. Yes.
In this word order issue.
I'm denying.
Very good.
I'll ask my client to be present here on Monday.
Then you kindly come with a written instruction whether word order has been issued or not.
Not sure.
Because if word order has been issued, a right has accrued in favor of another person, so he has to be implemented. You come with that written instruction to us because it is on the submission said that word order issued and he 2 points of rejection. One is originals not produced, that two are to have been published in the online.
Yes.
Why a physical notice to that effect? To this, your answer is all are locals. We are not required to do so. Anyway, we will consider that. And if you take instruction and come back on Monday and tell us the submission which you have made is right or wrong.
I will take it.
Yes, Monday.
Grateful.
Give a copy of this.
Today itself, within half an hour.
ID number 7. I appear for the plaintiff appellant. There's a defect, there's a delay of 277 days.
Single line order is.
Order for what? There was no, you have not, state government, you have not served as yet.
Today,
Pradhan, she is appearing.
today also I'll serve both of them.
Acha, call her.
Lots of
Ashok Thakur. Yes, she said that file take without the know. What is your name, madam?
My name is Miss Ankuna.
We can engage you for
Pradhan only.
hard history. Blooded advocate appearing for the appellant.
Mr. Vikas is here also for state.
You
He was appeared in that matter.
So you can appear also.
Vikas Singh was there, appeared. His name is there in the order.
No, he may have appeared. There has to be a fresh engagement in his name.
I'll give
All
you a copy
everything
today.
cannot be done in this one.
Thoughts. I'll serve it in the
Hard
office.
Mr. Sergeant Learned Advocate appearing for the appellant, Miss Learned Advocate.
Ankona Rokit.
Miss Rokit Learned Advocate enters appearance on behalf of the respondent numbers 2 and 3.
No, no.
Only two.
Petition only, I was requesting, respondent number.
Pradhan.
The
Pradhan with personal capacity.
So, how personal capacity? He is not implemented by name. Pradhan has been implemented. Gram Panchayat also then you can appear. Acha, down. Miss Rokit Learned Advocate enters appearance on behalf of the respondent number 2 and submits that no copy of the stay application has yet been served. Stop. That is a stay application.
Lordship, it is here. Can one.
Stop. Next paragraph. A copy of the stay application has been handed over to Ms. Rokit in court today to enable her to avail necessary instruction.
Lordship.
The Mr. Sergeant is also directed to serve copy of the stay application upon the respondent numbers 1 and 2.
1 and 3.
1 and 3 intimating that the matter will be taken up on Monday.
Lordship.
And to file a service on the returnable date. Establish the matter for further consideration on Calcutta, সোমবারের date দিয়ে দাও।
I'll get it.
Got the copy section.
Immediately, 15 minutes. I'll make it Xerox and send.
I mean, sir, you also see if it is served in the GP office, you can also say that you appear. Then you avail instruction. We cannot direct you to appear just now. Yes.
Number 7. Appear for the appellant plaintiff. There's a report, there's a delay of 277 days. Now, my lord, due to my oversight, my lord, an application for condonation of delay has not been filed. My lord will kindly place it in the next circuit, my lord.
The learned advocate appearing for the appellant prays for an accommodation to take appropriate steps in the matter in view thereof. Is the matter for further consideration before the next favorable.
Grateful, my lord. My lord, may I say something, my lord? My lord, the bar, my lord, is grateful that lordship had taken up that issue with the filing section, my lord. Yesterday, we faced the same issue, my lord.
Let us see, sir, the problem has to be worked out.
Yes.
Immediately, it has to be, we have all have.
For the appellants, there's a defect in this application, or the copy of the decree has not been filed, I find, with the judgment. Judgment has been filed, so the copy of the decree has not been filed. And this is the first appeal against challenging the reports granted under section 13B on the ground of fraud.
Now you have got the decree.
No, decree I'm yet to receive. I'll be receiving in course of the next week, coming weekend.
Of next week.
Yes.
Then how
Certified
to-
copy has been applied for.
So certified copy you are yet to obtain.
I'm yet to get also in my hand.
You see, most of the matters you see are not been able to take up either for non-filing section 5 or due to defects
Yes,
in
yes.
similar way.
Or what is happening because the lower
Otherwise, you see, so many matters can be
Yes, it has
proceeded
been
with.
taken up. I was actually willing to do it before your lordships, but because of the lower court.
You see, time is very limited, and if
Yes,
these
yes,
defects
and
come
and
up,
this circuit
what
is
we
also
can
not
do?
complete.
Mr. Raman London, appearing for the appellant. Prays for an accommodation to take appropriate steps in that,
Grateful, lordship.
in view thereof. The matter stands adjourned. Establish the matter before the next hearing. available, sir. In view thereof, the matter stands adjourned like that.
Item number 10.
My lords, the second appeal, my lords. There is a delay of about 49 days. Delay of about 49 days, my lords.
Third,
No, my lords.
application?
Kindly grant us leave
Oh,
to
right.
serve it upon the respondent.
Have you filed the application?
Yes, my lord, we have filed.
You see, section 5 applications, without that being served, court cannot take it up. So even if you desire also.
Shall serve it, my lord.
So in future, you see, whenever you to file section 5, serve it. Otherwise, things cannot be taken up.
Yes. Meanwhile,
Oh, section 5, can one দেওয়া আছে যে?
that is a delay.
Can one আছে তো? Anyway, serve.
Yes, my lord.
Can one is what?
Delay application.
Stay application.
No, delay.
Have
Section
you
5.
served?
No, we have not.
Accordingly also.
We shall serve, my lords. Let this be placed before the honorable single judge consideration.
No, this is a second appeal, section 5.
Section.
Yes, section 5 has to be heard by the single judge.
Let it be placed.
Yes.
And my lords, I had seen.
Yes, record an order. Learned advocate for the appellant is present as section 5 application for condonation of delay in second appeal is to be taken up by the learned single bench. Let the matter be placed before the single bench having determination.
My lords, one more thing. There was a defect. If I
A
may-
service in the meantime.
Yes. There was also a defect. I could see it in the call list. If I could correct.
What
the course of the day. I'll have to see, my lords.
Defect is for port fee not paid. Port fee you have paid.
Would be, I think, paid.
There is no other defect.
The call list was showing defect. I don't think. Perhaps it is because
Defective for section can one টা কোথায়? Can one টা কোথায়?
perhaps it's because I've written memorandum of appeal from original judgment. It should be appellate judgment. In the first title, my lords.
That has not been indicated by the stamp reporter. That way entitled appeal, yes. Where do you have said appellate order?
No, I've said original judgment in degree in the memorandum of appeal, the lordship shall. At the top. This is just conjecture on my part.
Appellate decree.
Yes. No, I've written original judgment. Perhaps it should be appellate judgment. Just quickly. If I may make the correction.
Let's do the single bench.
CD5,
Yes.
it has not been pointed out.
Yes, let me just.
Item number.
Order 41.
Yes, order for. This is against refusal of an injunction, additional injunction prayed.
Just wait. We were given the wrong file. Oh, আচ্ছা আচ্ছা। ওটা কি অর্ডার লিখেছি বলো? Don't switch off. Read it.
As section 5 application for conversion of clear, second appeal has to be taken up by the land of bench for late matter before the land of single bench and
Learned advocate shall take necessary steps to remove the defect as pointed out in the meantime. And then mention before the single bench.
It's pointed out by.
As a, remove the defect as pointed out by the stamp reporter. আচ্ছা, পরেরটা হলো admission.
I
Second admission, Johnson line, addendum. Yes, there is no caveat in this matter.
No caveat.
Refusal to pass addendum order.
Interim order of injunction. Now, my lord, plaintiff is the appellant before.
Have you
the court.
served?
No,
But there is no caveat order for.
Oh, no caveat.
Roshan কি বলছে?
ফাইলটা দাও, ফাইল।
Item 11.
Item 11. Nasib. Now, my lord, this is a suit for specific performance. Now, in a specific performance suit, my lord, I pray for my lord, an injunction. My lord, not to alienate, not to encumber, and not to my lord, change the nature and character of the my lord, suit property. My lord, that injunction has been.
Specific performance.
Suit for specific performance. What happened, my lord? The defendant will not enter into an agreement, my lord, for sale with us, and my lord, initially, my lord, as an ad hoc payment, they have taken, my lord, 1 crore and 6 lakhs. My lord, that is admitted by this. Now, my lord, after admitting that, my lord, what happened, my lord, the court has gone into, my lord, the question, my lord, the balance, my lord, which is required to be paid, my lord, has not been paid. Now, my lord, we have raised a question before the court. We are ready to pay the balance. But, my lord, prior to that, there was a stipulation in the agreement saying that prior to, my lord, execution of the final deed, they have to forward us with the all original documents and deliver the possession. Now, my lord, court
Had to,
prior to, my lord, execution final deed, my lord, they have to, my lord, comply with the stipulation in the agreement which says all original documents have to be, my lord, given to us, and, my lord, the possession has to be handed
So
over.
what is the
Lord-
ground for refusal? That
Yes.
you have failed to pay the balance
Balance
consideration.
consideration. My lord, knows my lord, a suit for specific performance. My lord, the readiness and willingness continues till the, my lord, even at the appellate stage. My lord, prima facie, my lord, holding, my lord, that I am not ready and willing. My lord, without considering.
So was there any pleadings that you are
Yes,
ready and
yes.
willing?
Yes, that pleading was there. And my lord, moreover, my lord, further, my lord, what happened, my lord, in the meantime, the defendant, my lord, appears and, my lord, apprises the court that they have entered into another agreement with a third party. And, my lord, they have, my lord, going to sell the property at 13 crores, where they have agreed to, my lord, sell to us at 10 crores. Now, and, my lord, as an advance, they have taken 15 lakhs, 10 lakhs. Now, that would be reflecting from the impugn order. My lord, later portion, my lord, will find at the last page of the impugn order.
10 lakhs, yes.
Yes. So, my lord, as an advance, my lord, he takes from me 1 crore 6 lakhs.
No. Oh, right.
And, my lord, for a subsequent party, my lord, without, my lord, completing the sale with me, my lord, he takes, my lord, 10 lakhs as advance, my lord, for 13 crore.
Now, did he terminate the contract?
No. That is most important, my lord. What court says, my lord, is that kindly takes up the impugn order once. If my lord takes up the second page, it is submission though. Second page of the impugn order, just few lines above the last paragraph. This is the submission that the agreement.
That is
was
last page,
Second page of the impugn order.
page 81, 82.
Lord, I am reading from the memorandum.
No, I am reading the impugn order.
Yes, my lord,
Page-
internal page 2 of the impugn order.
Internal page 2, yes. It
But-
appears from the,
Defendant appeared, do not find that paragraph in the internal.
yes.
My lord, kindly takes up the bottom to satisfy my lord's query. My lord, this was the submission. At the bottom of that paragraph, defendant have no option 7 except to terminate the said agreement after long as 7 months from time and from the date of execution of agreement for sale dated 28 February 2021. Said agreement for sale was automatically terminated. How can it be automatically terminated?
that clause may have been there when you are paying.
No, Lord, there was no such clause. Lord, that's why I take a lordship to the agreement, Lord, itself.
Yeah, just a minute. Just give us 2 minutes.
Yes, yes.
Did you file the suit prior to expiry of 7 months?
No, my lord, after expiry. My lord, what happened, my lord?
56 lakhs you paid, 56 lakhs you paid.
Total 1 crore 6 lakh she admits.
Where is that admission?
My lord will
Total
find
value was 10 crores, no?
total value was 10 crore.
Out
No,
of
my lord.
total concerns, an
Plaintiffs,
amount
plaintiffs gave.
she first paid as advance.
Yes,
Where is that 1 crore you have paid?
yes, my lord will find the first page of the impugned order.
Agreed,
56
to.
lakhs initially, then again 50 lakhs was made by the plaintiff, and this fact has been admitted by the defendant.
An oral agreement of 10th January 21,
Yes.
10 crores, and 50C will be paid as advance, and balance will be paid paid 36 lakhs
No, 36 lakhs in
by
checks and
two checks,
yes,
15 lakhs by another check, 30,
6 lakhs
and
in
cash
cash
6 lakhs to them.
and 20 lakhs by another check.
So what is the total?
Then we not again, one agreement for sale was executed such and such in between Kanak Kanti Chakraborty and defendant number 1 and 2 and the plaintiff was receiving the advance amount of 50 lakhs. After execution of the agreement of sale dated such as the plaintiff insisted Kanak Chakraborty and defendant to put the plaintiff in physical possession of the suit property. In the meantime, said Kanak Chakraborty died. Defendant number 3 is the daughter of said Kanak Chakraborty. Further advance payment of 50 lakhs.
So there are two agreements.
Initially,
One was an oral
with the
agreement.
father, Millard by father oral agreement, by check 56 lakhs, 6 lakhs cash. And Millard when daughter entered into a written agreement, which is under the 40.
When was the written agreement?
28 February
Feb
2021.
Then
Now,
you
then
paid
she-
to father 56 lakhs.
56 lakhs.
And then pursuant to that oral agreement.
Oral.
And when you entered into an agreement with daughter,
Daughter asks for another 50 lakhs to
Very
give
good.
possession. After execution of the agreement.
that you paid.
That I paid. Then that admission, my lord will find in the second page.
You approached Mr. Chatterjee after 7 months.
Yes, because time is not the essence of the contract. Why? Because initially the time which was fixed, that was extended. So, Milord, it's not a case, Milord,
Where it was extended.
Milord, initially, Milord, if Milord takes
That
up
oral
my claim.
agreement.
Oral agreement, there, Milord, after the written agreement,
Now this pertaining to the same property.
same problem.
So oral agreement you entered within 7 months, I will pay the remaining, take 56
Yes,
lakhs.
but prior to that, Milord, there was a stipulation in the agreement that you have to hand over me the possession. Milord, after taking that for that possession, Milord, she takes another 50 lakhs, but she doesn't hand over the possession. We insist upon
56 lakhs to oral agreement to with
টাকা তো অ্যাডভান্স তো নিয়েছে অ্যাডভান্স নিয়ে ওটা কমপ্লিট করছে না এটাই গ্রিভান্স তাহলে প্রাইমার ফেস
এটা না দিলে কমপ্লিট করবে কোথায়?
প্লেন্টিভ এন্ড প্লেন্টিভ মধ্যে তো বলা হচ্ছে রেডি অর উইলিং টু পে
না 7 months পিরিয়ডে বেতন অ্যাপ্রোচ করে।
এবার কোশ্চেনের ওকে তো টার্মিনেটও করেনি এগ্রিমেন্টে যদি টার্মিনেট করে দেয় তাহলে একরকম কি
বলেছে তো
এবার যদি অন্যকে বিক্রি করে দেয় থার্ড পার্টি
দিয়েছে।
না বলছে করেনি আর কি অ্যাডভান্স নিয়েছে তার থেকে
Your specific performance suit was pertaining to the second agreement.
yes.
Now what is the defendant's case?
Defendant case is that, Milord,
ইট ওয়াজ অন কন্টেস্ট
this was this judgment is not contest.
Contest. What is the
রিজেক্টেড অন কন্টেস্ট পরীক্ষা Yes, in page 83, with whom did the plaintiff make agreement? With another person to sell the suit land?
No, no, with the below defendant.
No, that is the third paragraph in page 3.
Page 3 below. Yes, that is the third part.
That means you entered into an agreement with the third party.
No, the defendant.
No, here it is. Moreover, the plaintiff entered another agreement.
My lord, is reading, my lord, the internal page 3.
3,
Yes, my lord.
the third paragraph. Moreover, the plaintiff entered another agreement with another persons.
My lord, the internal page 3. Moreover. Yes, moreover, the plaintiff entered, this would be defendant, that is wrong.
It should be defendant entered into another agreement.
This is wrong. But that would be 45. From this first paragraph of that page, it appears from the record that another agreement for sale 7/4/22 was executed between Arpana Pitan and Sharonno in one part and Joy Ma Durga.
How much amount is due and payable now?
Balance would be 8 crore 90 lakhs or.
So you are ready and willing to pay
If
within?
they put me now, if they put me in possession, I will pay off because that was the agreement. When we asked them, you put me in possession, then she is not putting in possession because this would be apparent from the pleadings as well. She is searching for a higher amount. And once she get a 3 crore more, she puts Joyma Durga into possession at an advance of 10 lakhs.
That has already been done, it seems.
So, today the nature and character has to be preserved. If I succeed in the suit, that I was ready always.
No, Mr. Chair, kindly come to the penultimate page of the order.
Yes.
Second paragraph. What is this? You entered another agreement of 7th April?
No, that's a wrong record.
A wrong record for the defendant.
The defendant
entered into another agreement.
No, no. আর আগে পড়ে
তার আগে
প্রথমে দেখুন এইটা পড়ি না।
Which part?
It appears the second paragraph of the
internal page 3.
No,
the page 3.
Page 3, yes.
Page
It
3
appears
up
from the
top.
record.
Yes.
Another agreement for sale dated was executed between Aporna, Bitan. These are not the plaintiffs, these are the defendant who entered into agreement with Joyma Durga. This is the another agreement.
This is pertaining to the same
plot of
property.
land.
So your first order deed was on 2021 February,
Yes.
and the second written deed was
28
February 2021. 7 months takes you to 20 September. And we executed that
in April.
Thereafter. October, November, December, January, February, March, April. 7 months thereafter. Now compilation has been created. Now you are wanting an interim order not to change the nature and character.
But initially it was coupled with not to alienation with not to change nature and character. Now that the alienation goes because she has already done.
No, executed or just taken advance. You see, it's sold, that is one thing, and
not
just
sold.
that is entered into an agreement.
But possession has gone.
Entered into an agreement. Agreement for sale, agreement কাগজে কলমে হয়েছে, possession দেয়নি তো, এটা সেল ডিডও করেনি, শুধু অ্যাডভান্স নিয়ে একটা এগ্রিমেন্ট করে দিয়েছে।
But that's a contention in the court below that she has given possession.
No, agreement, just an agreement. Just nowhere it is stated conveyed the property.
Internal page 3,
Yes.
second paragraph, kindly see.
Yes.
ওইটা তো reasoning এ ঢোকায়নি।
হ্যাঁ, ও তো সেল করে মানে
ব্যাপারটা reasoning এ ঢোকায়।
না, absolutely correct. শুধু বলেছে ব্যালেন্স অ্যামাউন্টটা দেয়নি, অতএব ফেল। ও তো দিতে আছে, রেগুলেট করেছে তো।
Then what interim order you?
Not to change the nature and character. If tomorrow this Joyma Durga enters and develops the property.
That means not to part with possession.
Not to part with
Not
possession.
part
not
with
to change
possession.
Nature and character.
We don't know whether possession has been given.
No,
or
that is not the contention.
এখানে ইন্টারিম অর্ডারটা রিফিউজ করে দিয়েছে।
She was there in the court. She could have apprised the court.
Interim order was rejected on contest.
On contest.
And what was your prayer for interim order?
I have prayed threefold.
Yes. Yes, restraining from alienating, transferring, and
not
or changing.
not to change the nature. So, my lord, if I take that our contention is correct, that
From
that
the order of the trial court, nowhere it appears it is alienated. But entered into an agreement.
semblance of right has been created in favor of a third party, though not complete alienation has been done.
Or neither the third party is put into
Put into
possession.
possession. Lord, so, my lord, today
Did they use any, it was an interim order?
no, my lord.
Contest.
So where is their
Objection.
written
Yes,
objection?
yes. Kindly takes up, my lord, my stay application.
Page 78.
My lord, her written statement which is filed at page 72 and the written objection.
Oh,
my lord,
written
78.
When is it been made returnable for hearing of the interim order? Final?
No, my lord, till finally disposed of.
Oh, final, not an
Final.
interim order.
Yes.
I contest a figure. During pendency of that injunction application, you are enjoying the interim order.
Yes.
What interim order you
My
are
lord,
in?
not to change nature and character.
Where is that?
My lord, I shall get hold of a copy that will later on be.
That does not stands mentioned in this order passed by.
No, because this is final adjudication, it
No.
number.
No,
interim order.
any observation that you obtained an interim
But
order?
truly speaking, my lord, I haven't also checked up that, but on instruction, I say initially there was an interim order. Reported by the clerk of the sheet. My lord, if my lord takes up in the meantime, my lord, I get hold of that thing, my lord. In the meantime, my lord,
No, we are wanting to know what was the exact nature of the interim order which you obtained.
yes, my lord, I shall.
Did you get an injunction upon
No, I will
alienation?
check up from the internet. But I've asked him to call the counterpart.
Written objection.
My lord, the written objection which is filed by the defendant.
There nothing has been stated.
Nothing,
It
but
is
in the written statement, that's why it was taking my lord to the written statement. Page 72. Well, I can hand over.
What, tell us now, what did you get?
Well, not the exact tenor of the order, but order dated 6th of March 2024 in the trial court, order number 12. The interim order of temporary injunction hereby extended till the next date on the prayer of the plaintiff.
What was the temporary injunction?
Dara. Well, give me 5 minutes of time. Lord, I shall from internet and try searching. ওই প্রথম অর্ডারটা যেটা রিসিপ্টটা দিয়েছিল কাউন্টার পার্টকে দিয়ে না মুখে অন্তত বলতে পারবে। Now, my lord, the relevant part with regard to the alienation and creations, my lord will find page 75, paragraph 70. May just place it paragraph 70. In that, in respect of the statement made in such as such, even the plaintiff had never ready and willing to pay balance consideration and get the registration of the suit land in spite of several requests as made by the defendant. It is absolutely false. The defendant have demanded the extra money from the plaintiff beyond the agreed consideration for giving the registration of the suit property in their favor. It is further stated that after demise of the husband of the defendant number 1, the said balance consideration was desperately needed for the defendant for meeting their financial crunch, including the liabilities left by the husband of the defendant number 1 in the present market, and same has been repeatedly conveyed by the defendant, but they did not pay any heed to that. and due to the said negligent act and failure to perform specific terms and conditions of said agreement dated such as the defendant had no option save and except to terminate the said agreement, and after efflux of time and elapsing of 7 months period on, and from the date of execution of the said agreement, the said agreement was automatically terminated.
They have not shown.
Now, my lord,
কিন্তু ready and willingness টা বলেছে তুমি। Proposition of order তুমি নিজে তো violate করেছো।
this is
There is a dispute with that. দুটো জিনিস subject to whether you are ready and willing, readiness willingness টা তুমি apparently দেখাতে পারছো না। আর এই দিকে কিন্তু অন্যদিকে যেটা এবার সেটা হচ্ছে যদি করে নেয় তাহলে আবার থার্ড পার্টিকে করে দিল কি করে, এটা তো মানে ম্যাল বোনাফিড, এটা থার্ড পার্টিকে 7 মাসের ভিতর করেনি, থার্ড পার্টিকে এক্সিকিউট করেছে, টাইমটা তো ঠিক আছে, শুধু 7 মাস নয়, 7 মাস প্লাস 7 মাস, দে ওয়েটেড ফর মোর দেন 14 মান্থস। ওরা কোনো চিঠি দিয়েছে কিনা রিগার্ডিং রেডি অ্যান্ড উইলিংনেস প্রদেশন? আমি ওই 14 দিনের মধ্যে তো চিঠি দেওয়া উচিত ছিল, we are ready and willing to give the documents. Keep the documents.
Yes, yeah, did you give any letter to supply those documents for which you will pay the balance amount?
Lord, kindly text my plane once, my plane. And not the agreement first, before taking my lord to the plane, the agreement. Lord,
No,
which is
Mr.
that
Chatterjee, we are one, your readiness and willingness, your contention is that cannot stand automatic, agreement cannot
to be
stand
stand
automatic.
automatically terminated.
This is one.
This one.
So one argument is that admittedly, you did not pay within 7 months, not even within 14 months.
Now, my lord, here.
Now, your readiness and willingness that due to these problems or due to non-supply of this, I am not saying. If you can show us that to us, then we can prima facie assume that there is a
Lord,
readiness
that
on
would
your
be
part.
apparent, my lord, on two things. My lord, on seeing the agreement and on seeing the written statement. Now, my lord, what in the agreement, it is specifically awarded, my lord, kindly takes up the agreement, which is my plain case also. Page, it starts from page, my lord, 52. And my lord, the relevant paragraph of the agreement.
এই সুজিত, এটাতে একটু জল দিয়ে দাও তো। $52, yes.
Relevant paragraph, page, paragraph 11, page 59. Paragraph 11, 10 and 11 both, but I'm pressing on 11 now, my lord. That is time of execution of this present agreement. The second party shall hand over the physical possession of the below scheduled land and relevant papers of the below scheduled land to the first party, that the first party shall have liberty to conduct the 3 boundary wall in and over the below scheduled land prior to the final registration. So, my lord, this is where, my lord, everything stalls.
That means, it is
Lord,
not
I
an.
give him 1 crore, you give me possession so that I can go for final registration. My lord, she doesn't comply her part. Rather, it is evident, my lord, from
That
the
means at the
written
time of execution of that agreement, you had to be put into the possession.
Absolutely, because she is taking 1 crore. And now, my lord, she comes up in a defense. She says, my lord, I need money in the market. I need more money. And my lord, she puts into possession.
So where is
my-
that 7 months
Yes,
condition?
that paragraph. My lord will find paragraph 3.
Paragraph 3. That means within 7 months, you had to execute you have to pay, and they have to put you in possession
Yes.
simultaneously.
Yes. So, my lord, she doesn't give me possession. She is demanding that 8 crores.
So why did you pay that advance amount when you are not
My
given
lord,
that
That's
possession?
exactly, my lord. She says, my father died. She takes another 50 lakhs. Her father
And
took 50
any letter from your side to hand over the possession?
My lord, that's what, my lord, she says in the written statement.
But why did you keep quiet then? The clause 11 which you showed us, that at the time of execution of the present agreement, the second party shall hand over physical possession.
Yes.
So you.
My lord, 21, thereafter pandemic invoked, my lord, nobody, my lord, was moving out of the house. So after pandemic in 2020, end of 2022 and 2023, when we were asking
Did
to
you
deliver
take that? Did you take that apartment in your plane?
Yes. Now kindly takes up
Where is that COVID count you have taken?
paragraph 13, page 27, plane starts, my lord. 20, plane starts from page 20, 13 is, my lord. COVID-19 pandemic paragraph, 14 also continues.
ওরা
Then
নিজেরাই
15.
বললো যে এক্সিকিউট করো না। পেজ 27 প্যারা 30,
Yes, yes.
যেটাই বললো যে করো না এক্সিকিউট।
সেইটি তো ও তো টাকা জোগাড় করতে পারবে না অ্যাডমিটেড পজিশন অত কোটি টাকা, ওই জন্য টাইম দিতেই হবে, অ্যাট দ্য সেম টাইম তাকে পজিশনও দিতে হবে, দুরকমই জিনিস রয়ে গেল সাইমালটেনিয়াস।
না না, ও তো বলছে আমি টাকাটা দেবো,
হ্যাঁ, purchase, হ্যাঁ,
করছি না। ওখানে কোনো কথা বললো না যে আমি ডেট অফ এগ্রিমেন্টই তোমার পজিশন দিয়ে দেওয়া উচিত ছিল।
আর সেটা এগ্রিমেন্টটা কি ইয়ে করেছে,
এখানে কোথাও নেই।
রেডি অ্যান্ড উইলিং টু পারচেজ দ্য সুট প্রপার্টি, এক্সিকিউট দ্য ডিল।
কন্ট্রাক্ট রিভিউ
এই যে কোভিডের জন্য ওটা হয়নি, হেল্ড আপ হয়নি।
আর show us one document that you approach them that you why you are not executing. COVID
No,
we
Milord,
understand. একটা কিছু তো দেবে।
What happened, my lord, on 4th February 2022, my lord, this
Another-
paragraph number 15, if my lord sees. My lord, we insisted them to put us in physical possession as per the agreement. When she said she required 12 crores. And we stuck to 10 crores. As per the agreement. And now it is clear, my lord, as she got 13 crores, she gives possession.
ঠিক আছে, টাকা পেতে সব সেটা করে যেতে পারে দুটো
সাকসিড করে
I mean, Lord,
তোর অ্যাডভান্স দিয়ে কি হয়েছিল টোকেন অ্যামাউন্ট 10 কোটি টাকার প্রপার্টি 56 লাখ দিয়েছে, এক তো পিও দেয়।
my lord, one of the
Lordship, item number 12. Lordship, I have been mutated by this on the
আপনি মেনটেন করছিল বলছিলাম বললো কি মেনটেন করলো তো কি বলছো ও ওই তো মিশ্র তো ওয়েট করছে অ্যাপেলেন্টের জন্য না মিস্টার মিশ্র ওয়ের ইজ ইউর আদার সাইড অলরাইট do we take
Malad, I am here, Malad. Virtually, Malad, I am appearing, Malad.
Acha, just answer one question of ours.
Malad.
In your একটু ফাইলটা দাও Mr. Misro's argument was
Yes, Malad.
that you could not have given the issue for consideration to a consultant in terms of the NIT provisions.
Yes.
And in your note which you have placed before us, that is at page 300 and 419.
Yes, Malad.
In 419, in paragraph 6 or 20, in paragraph 6, you yourself stated that yes, we have given it to a consultant of WBHC.
Malad, this when this Heritage Commission, Malad, undertakes any Malad, such type of renovation or restoration work, then they appoint a consultant, Malad. Take engineer from the
Our question, Mr. Chaudhary, is the eligibility clause was conservation, restoration, including what is the term?
retrofitting.
And of items under WBHSC
Yes.
or archaeology department or any other equivalent.
Equivalent any other government department.
So, if Mr. Misro is limited to the issue that, or contrary to Mr. Mitro's submission, you have submitted that his credentials were pertaining to a work
Malad.
which has a bearing with the issue in question. As such, you may have said that West Bengal Heritage Commission has not found the work to be credential to be appropriate. But his argument is that you are sending it to a consultant. The technical bid committee is the authority.
Yes, Malad.
So before taking the decision, you yourself, you are saying that yes, we have sent it to a consultant.
Malad, why? The reason behind is the Malad, because the moment it is said that this is the building is required for restoration and renovation work, and the credential which he has submitted, Malad, which also a building listed under the Heritage Commission. So in this capacity, the work which he has undertaken as a credentials, whether the similar nature of work which he has undertaken or not with regards to a restoration or renovation work, this is the reason, Milord, or whether this work was at the behest of Heritage Commission. This
That was also an item under WBHC, which he previously did.
No, Milord. No. That was the tourism department's request. PWD executed this work. And this is the Heritage Commission's work. PWD is the executing agency to undertake this Malad, the construction work. So
No, it is, you said na that work which he did is also listed under WBHSC.
No, Milord, the building, Milord. I'm Mr. Pal, I'm just clear, Milord. The Heritage Commission has listed these are the buildings under the Heritage Commission. This is one part. So the Jagannath Temple, Mashir Bari Temple is also listed under the Heritage Commission list, Milord. Similarly, the Graham's home is also listed under the Heritage Commission's list. The question is that Jagannath Temple in Sirampur, Hugli, the execution of the
All right. But suppose he has completed work in respect of a building which
Yes.
is not listed under WBHC,
Yes.
but his credential
Yes.
is supported by, say, archaeology or other government
Definitely,
authority.
he is eligible. He ought to have been eligible. Because my lord, my is a very narrow line here. My lord, kindly appreciate. My lord, my argument was that because it is a specialized skill and technical expertise required. So this is the reason the restoration, renovation work, retrofitting work, whether he has the credential or not. If he has undertaken restoration,
No, what would have been what would have been the bid committee's function? Suppose the work was not is not pertaining to a building which is listed under HBHC.
my lord, question of the if it is listed or not listed, that is not the eligibility criteria. Qualification is that to meet whether the similar nature of work with regards to restoration, renovation, retrofitting work, whether he has undertaken under these agencies, the equivalent in the government agencies or Heritage Commission or Archaeological Department. Similar, whether the building, irrespective of listed or not listed, this qualification he must possess. Because
So
he
this qualification who will determine? Suppose he produced tourism department, all right, we understand that it was a listed building, it was sent to him. Suppose suppose he has obtained that, say, in respect of say that Heritage Conversation Committee of Ahmedabad.
my lord,
If he had, because that you have stated in paragraph 5.
I said, my lord, the reason what I said, because this is the, my lord, the kindly now for the time being, let us forget whether the building is listed or not listed.
Yes.
Now let us come then the qualification required in the ENIT, that restoration, renovation work with retrofitting experience and the eligibility criteria.
Very good. Yes.
That credential he has to possess and work executed as a credential under Heritage Commission, Archaeological Survey, Gujarat or whatever Miller and equivalent government agency. That credential must he has possessed, and then definitely he would be eligible. Now, what is the credential he has submitted?
No, forget that. Now then, suppose he was produced a credential of archaeology.
Yes.
You said whether the technical bid committee will consider whether that credential matches with the credential required for this work under the tender.
True.
This is the jurisdiction of technical bid committee.
Absolutely, Millard. Absolutely.
Then where from? Decision has to be from the technical bid committee. Why you are sending it to another agency?
I have indicated, Millard, as I have indicated yesterday, as my Lord Justice Chaudhary even was insisting me, even has fallen from my Lord's mouth, that the tender evaluation committee can revisit and independently will take decision with regards to his my Lord the credential.
No, that is Justice Chaudhary, my brother said that revisitation we may consider.
Yes, was thinking.
We are thinking. So suppose today, how do you meet Mr. Misro's argument that for technical bid committee for determining my suitability can ask for a certificate from a consultant that is not provided under NIT?
Millard, we have not sought for any certificate from the.
Exactly, you have done. Kindly come to page 420.
Millard, we have sought for a clarification. We have sought for a clarification because these two buildings under the listed.
So what would you have done? What would your technical committee would have done had his credential been of, say, Ahmedabad Heritage Commission? What your technical bid committee would have done?
Well, technical bid committee ought to have done on the basis of the credential which he has submitted. This is the technical evaluation committee's performance. Now, Millard, in one step further ahead, had sought for an opinion from the Heritage Commission whether the work undertaken with regards to this credential, whether the retrofitting or the work under the Heritage Commission or not. That is the clarification has been sought for. And on the basis of.
Was that line, Mr. Chaudhary, that this clarification can be sought for? Where is that line in the NIT?
Under ENIT, Millard, I must be candid, Millard. There is no such, because technical evaluation committee consisting of 5 members of 4 members, they are the Millard, the expert or the authority. No, my lord, we did not sweat upon the decision or the opinion of the Heritage Commission. Because, my lord, if you, my lord, see the paper once again, turn back, my lord. I just,
Yes, yes.
I'm not carrying the brief. That the evaluation committees, technical evaluation committees findings. Page, Mr. Pal, kindly
Yes, yes,
indicate.
yes. That is page page 409.
Something like that, my lord.
Three 330.
329.
Yes, 329, 330. Yes, yes, right.
Yes,
My lord,
yes,
come to 330.
yes,
My lord will find that the evaluation committee's members' signatures
yes,
at bottom.
yes.
Kindly see the findings. What they said, they never said that we have consulted the behest of the opinion which has been sought for from the consultant or the Heritage Commission. This decision is taken. This decision is independent. This decision is on the basis of the credential which he has submitted that the evaluation committee has decided. That is Millard. That's why I said maybe because if a Millard sees that the opinion or the any decision with regards to the seeking a opinion from a consultant or the Heritage Commission, that is Millard the tender inviting authority. That is the executive engineer, not be the entire Millard evaluation committee has decided. Then ought to have been in the meeting, ought to have decided, yes, this is our desire for seeking an opinion to come to a conclusion or to arrive at decision whether he possesses that qualification or not. This is not the case, Millard. Case is that independently the technical evaluation committee has decided.
You yourself has admitted that we have appointed a consultant.
May I put that to rest?
Millard,
One line.
I think I consultant is that Millard for execution of a war. Millard, this is the war under the Heritage Commission, my lord. Heritage Commission shall supervise.
Not page 334 for a moment. It has the reply to that. The answer that
Just a second,
page
Mr.
334. This is in reply to my representation.
That is the
The
divination.
tendering authority said, after verification of your credentials from the Supreme Heritage Commission.
No. Malad, kindly.
After verification of your credentials from the Supreme Heritage Commission, it is found that your bid does not comply with the criteria.
That is because it is
for itself.
Huh?
Order speaks for itself.
That is why court has said, no, that is why court has said you go to Heritage Commission, because what Heritage Commission earlier said was 2 points were answered. This point was not answered. I am sending you back to the Heritage Commission.
But the argument will not put to square one is again back to that. Where does the Heritage Commission comes into picture?
Yes, to that the answer is kindly come to page 29.
29.
Sorry, 36. It is an interpretation of the eligibility criteria. What is the eligibility criteria? You have submitted credentials in respect of a building listed under WBHC. Now, for whether that criteria of a listed building under WBHC matches with the eligibility criteria or not, who will answer? That is why it is said that we would have taken that point. I was with you initially, but that criteria specifies that credential for satisfactory completion of conservation restoration work comprising of retrofitting rehabilitation items under WBHC or other equivalent government runner. So suppose you have given from tourism. So tourism department work credential which you have given is equal to the credential of an listed building under WBHC. Who will answer this? Only the WBHC can answer that whether it is. Yes.
The PWD will answer it, because whatever happens is whenever there is a heritage site,
PW do not have the PWD is the
increase of POQ.
Yes, that is the your financial. That is a financial question. We are wanting to say that this ascertainment by the technical bid committee.
May I put it again? Suppose I have worked for a heritage site.
if the nature of work that I have performed involved heritage retrofitting, or then only there would be a 25% increase in my BOQ. In the credential that I submitted, there was a 25% increase. That ipso facto says that I work for a heritage site.
So clarification, even if you have given that,
Even with the bid evaluation.
no, that automatically does not mean that
It
you
does.
become entitled.
Yeah, because in the schedule that I was referring to yesterday, if I can have my lordship for a moment on the schedule first. The schedule rates in page 336.
That for such a specialized work, more money was sought
25% more
for.
would be paid.
That
In
is
that credential which I submitted, I was paid 25% tax. That is apparent from the certificate that I have submitted.
that will be considered. There are two parts of it. One thing, your argument is you throw away everything. Consultant, there is no scope of any consultancy.
Based on the credential,
Entire process is bad. One is this. And your other thing is that you please consider the BOQ you accepted from me.
That speaks for itself.
That
there is no need
itself-
for a consultant.
Mister, this is a heritage building which is to be, your credential has to be matched. You consciously did not appear in first call and second call. Third call you
Even if
appeared.
has been made. The
That is
quorum
your-
was complete.
Where is that BOQ you are saying?
Lord, page 337. All this was submitted along with the technical. Plus 25% for heritage work.
বলুন তাহলে কি করবো? ঠিক আছে, আনসার দেবো, ওদের আনসার দেবো। এখন আমরা বন্ধ করে থাকি, পাবলিক ইন্টারেক্ট বেসিস থেকে। কিন্তু একটা জিনিস আপনি দেখুন, page 420 the video evaluation committee. Finalize না টেকনিক্যাল অ্যাসপেক্টটা হয়েছে, কিন্তু ফিনান্সিয়াল অ্যাসপেক্টটা হয়নি। মানে ফিনান্সিয়ালি খুললেও যে অ্যাপ্রুভাল হবে সেটার কোনো গ্যারান্টি না।
Yes, my lord, true.
এবার এখানে হচ্ছে so far as allowed him to participate upon receipt committee will reassess technical and take a final decision. এবার প্রোটেকশন দিয়েছে ইন্সুরেন্সের সব কন্টিনিউ, আর কি ডিসিশন ইজ টেকেন বাই দ্য কমিটি, বাই দ্য and the communication they have to make. Is in communication করবে বলে দিয়েছে। এটার এগেইনস্টে তো গভর্নমেন্ট অথরিটি আসেনি না, they are accepting this.
In fact, Mr. Mishro, you will not suffer any prejudice because court has sent it the matter back to the Heritage Commission to
Give the report, opinion.
participate upon to give an opinion as regards the credential. This has not been appealed against by them.
Thereafter they will assess.
Thereafter they will assess. Your argument of consulting with a person or not, suppose the tender, there has to be some free play at the joints. Has to be some free play.
Has to be.
If I do not know whether the credential which you have given is matching with the credential of another work which is being proposed, how can I give that work to you? But it is not divorce the provisions of the NIT because the eligibility criteria itself mentions the Heritage Commission. The present appeal has been preferred.
The present appeal has been preferred, challenging an order dated.
Yes, Kumar.
Challenging an order dated 24th November 2025. Passed by the learned single judge in the writ petition being WPA 2031 of 2024. What do we say about? He said this petition was preferred by the appellant. Inter alia praying for issuance, inter alia praying for the following reading. Eta diesel page 32 85. Primarily praying for the following reading. Next paragraph. On contested hearing, the writ petition was disposed of by the order include stop. Said the operative part of the said order runs as follows. Equal marking. Mr. Mishra and the advocate appearing for the writ petitioner appellant submits that a notice inviting tender was issued July 2024, inviting applications from intending tenders, inviting application from eligible bidders. Stop. The appellant duly appeared along with the credentials. Stop. However, without considering the same, the authorities abruptly rejected the appellant's technical bid. Stop. The on a purported plea that the credential pertains to a work conducted by the Public Works Department under the administrative direction of Tourism Department from a government of West Bengal. Such reasoning is contrary to the eligibility criteria spelled out in the NIT
and a bare perusal of the same would reveal that the credentials are not only limited to items under the West Bengal Heritage Commission, bracket hereinafter referred to as WBH, but extends to items under Department of Archaeology and Museum or other equivalent government organizations. He argues, next one, he argues that under the NIT, the Technical Evaluation Committee is the sole competent authority to assess the credentials furnished by the leaders and to take a recent decision. However, in the present case, the Technical Bid Committee acted on the basis of a purported opinion given by a consultant given by a consultant of the West Bengal WBH. Such act is not such act is divorce the provisions of the NIT. He further contends that the respondents having
Page 29.
he further argues
Further contends that respondents have
having accepted the enhanced heritage BOQ rates cannot turn back, bracketed page 405, cannot turn back. Having accepted the 25% enhanced heritage BOQ rates. BOQ is
bill of quantities. Bill of quantities.
Bill of quantities, bracketed, in short BOQ, bracket close rates. Upon verification of the credentials submitted by the applicant, cannot turn back and take a stand that the appellant does not fulfill the eligibility criteria spelled out in the NIT. Mr. Chaudhuri learned additional advocate general denies and disputes the contention of Mr. Misro and submits that the Public Works Department is a general engineering department for execution of engineering works. And not for works within the domain of conservation of heritage structures. The eligibility criteria in the NIT itself includes a heritage workshop. The work under the NIT is a special work which associates preservation nature and is a special work associated with conservation stroke restoration work comprising of retrofitting stroke rehabilitation items. Stop. The credentials submitted by the applicant were pertaining to a work conducted under the administrative direction of Tourism Department, Government of West Bengal. In view thereof, it was the obligation of the technical bid committee to arrive at a definite finding as to whether the appellant's credentials tallies with the eligibility criteria as specified in the NIT. Stop the process adopted by the respondents. The process adopted thus cannot be said to be arbitrary or unreasonable. He further submits that the credentials furnished by the appellant are pertaining to a building listed under WBHC, and the work under the present structure is also pertaining to a building listed under WBHC. In view thereof, it was incumbent upon the technical evaluation committee to satisfy itself as to whether the credentials of the appellants matches with the eligibility criteria. In view thereof, it cannot be argued that the cannot be argued that that the authorities have acted in a manner which would benefit a private party at the cost of the authorities. We have heard the learned advocates appearing for the respective parties and considered the materials on. From the order impugned, in the order impugned, the learned single judge recorded that the evaluation committee sought certain clarifications from the WBAC regarding the appellant's credentials, and in reply thereto, it was reported that as per available records, the said commission had not issued any work order or completion certificate in respect of the project referred to by the bidder, and that no such work stroke project was recorded under WBS. Upon such clarification was not in fact a detailed one, and as such, the Honorable Court exercised discretion in favor of the appellant and observed that a specific opinion is required from WBHC as to whether the appellant fulfill the eligibility criteria, and accordingly and upon receipt of such opinion, the technical bid committee shall reassess the appellant's technical bid and take a final decision. Stop. Next paragraph. An appellate court interference. An appellate court interferes not when the ordered appeal is not right, but only when it is clearly wrong. Indisputably, the work under the tender is for conservation and restoration of a building listed under WBHC. Stop. The credentials furnished by the appellant are also pertaining to a building listed under WBHC. In the said conspectus, the learned single judge, in the said conspectus, and to come to a conclusion as regards the appellant's authority, the learned single judge relegated the issue for a specific opinion from WBHC. More so when the work under NIT is a special work associated with conservation stroke restoration comprising of retrofitting stroke rehabilitation. The clauses of the NIT needs to be read in its totality. A single line cannot be picked up.
Single line cannot be picked.
Excellent. Get it out. The conditions, the clauses থেকে ওটা কেটে দাও। The conditions incorporated in the contract agreement, the conditions incorporated in the NIT need to be considered together and not in isolation. Stop. Considering the fact that the work under is not in isolation. Stop. The eligibility criteria under NIT itself pertains to items under WBHC or other governmental organizations. The appellant's credential are pertaining to an organization other than WBHC. And in view thereof, it needs to be ascertained. And in view thereof, it was an and in view thereof, to ascertain the eligibility, WBHC can opine as to whether the work under DNIT and the work and the credential furnished by the appellant are similar. In the said conspectus, the issue was delegated to the WBHC for such special opinion. More so when the building under the more so when the work it also আচ্ছা ওই মিস্টার চৌধুরীর কাছে বলে দেবে মিস্টার চৌধুরী further submits that in the first call and the second call pertaining to the same work, the appellant did not respond, did not participate.
No.
Did not participate. It was last in the said conspectus. We do not find in the said conspectus and upon dealing with the factual issues, the learned single judge Pass the order upon. In the said conspicuous, we do not find any infirmity in the order include warranting interference in appeal. Accordingly, the appeal and the connected application are dismissed.
In terms of the order of the trial.
Acha, in support, Mr. In support of such contention, in support of the arguments advanced, reliance has also been placed upon the judge unreported judgments delivered in such and such. It is well settled. Unreported judgments is well settled at parental that a decision is an authority for what it decides. And the judgments upon which reliance has been placed are distinguishable on facts. ওইটা বলেছেন an appellate court interferes only when it is ওইটার সাথে আরেকটা লাইন লিখে দেবে an appellate court should not ordinarily interfere with the discretion exercised by the learned court, by the learned single.
Yes, the authority to act in terms of the order of the trial.
As the
Calcutta's order is not challenged.
as the period by the order as this period specified in the order by the impugned order, the committee was directed to reassess the technical by the
committee was directed to
they were directed to reassess the appellant's technical bit, by the order impugned. It was directed that the bid evaluation committee, upon receipt of opinion from WBHC, reassess the appellant's technical bid and take a final decision within a period of 3 weeks from the date of communication of the order. Due to the pendency of the said, during pendency of the present appeal, the said period had already expired. In view thereof, the said period is extended for a period of 4 weeks from date.
2 weeks sufficient, my lord. Already we have initiated the process.
Oh, you have initiated, all
Yes.
right. By is extended is extended till
15th January করে দিতে পারবেন?
Yes, my lord. Yes.
15 January.
Is extended till 15 January 20.
পৌষ মাসও শেষ হয়ে যাবে। Grateful, my lord. Sorry, my lord, for 2 days I have given trouble a lot.
Sorry, Mr. Mishra.
কিছুটা প্রোটেকশন থাকলো, কভারও হয়ে গেল জাজমেন্টে, হাইকোর্টের বেসিসে কিন্তু রিলিফও পেয়ে যাবে ও।
much available, sorry, these 2 days I have given a lot of trouble,
No,
because
no, part of
After all, we have been able to dispose it.
yes, yes. Then I am leaving, then.
yes.
May I permit to mention, my lordship, this matter is, I am requesting to take by this court, my lordship.
List দিয়ে দিও। Your cancellation of bail order এসে গেলে লিস্টে দিয়ে দিও।
Item number 1. About the petition.
What does it, your, my lord, front for 1 and 3. Actually, it's what
On last occasion, Mr. Das, on that point you have took time.
Alright, password.
No, my lord, but Obidit Sarkar said that I am not interested with that case. Kindly try to remember, day before yesterday. Day before yesterday, Obidit Sarkar stated, I am not interested.
Call him then.
Yes.
Call him password. Yes. Password. Yes. 3 term password.
Item number 4.
Who is your other side?
Yesterday.
Why state is not here? These APPs are not here?
No,
Why?
it's in,
Call him, call him.
Yesterday, your lordship had heard this matter.
Where is the why? Why is state not appearing in this matter? You're there.
Yes. This is that matter, lordship. Earlier case was started under section 498 and 302, and charge sheet against this petitioner was submitted under only section 498. I had given this copy of the charge sheet yesterday, lordship. Highlighted the portion where the involvement.
Who are you?
I am the father.
Charge sheet দাও। Show it to Mr. Luxa.
Yes, facts broadly related. What is there in the case diary is that, lordship, there is one consistent statement of the accused that he killed his wife and the murder weapon was recovered from his assistant.
That
From the principal.
primary
Husband.
principal.
That is the husband.
So the husband is on bail.
No, he is in custody.
This is custody law. And it is part of 85 of which is 498A and 103 which is 202.
Entirely
The allegation is against the article. 85 lordship sees the apparently primary there is some mention. Otherwise, rest of the case lordship it only alleges the husband lordship.
Apprehending at his present application, learned advocate appearing for the petitioner submits that the petitioner is the mother-in-law of the father-in-law of the victim. Aged? Aged about 76 years. Stop. No overt act has been aged about কি হলো?
76 years.
No specific overt act has been attributed to the petitioner, and the ingredients of section 103. 103 bracket
1, 3, 5 of yes.
103 within bracket 1 stroke.
Stroke.
No, 35 is what?
Common intention.
No ingredients of section 103 BNSS are attracted against the petitioner. There is no scope, as would be explicit from the charge sheet already submitted upon conclusion of investigation. Where is that portion marked out?
Highlight the portion.
It is not there. Highlight it.
Lordship is there in the case diary itself.
Sir, in the there is also no possibility that the petitioner would flee from justice. Mr. Luxam, learned advocate appearing for the learned appearing for the state respondent, has placed before this court the charge sheet, has placed before this court several documents in the case diary, including the charge sheet. Having heard the learned advocates and considering the charge sheet already submitted, and as prima facie the provisions of section 103 of BNSS are not attracted against the petitioner, I am of the opinion that custodial interrogation of the petitioner is not necessary, more so when upon completion of investigation, charge sheet has been submitted. Accordingly allowed in the notification of 480. Yes, next. এই চার্জশিটটা দিয়ে দিন। এটা থাকুক এখানে।
Part third matter is going on, that's why not to leave my court, that's why I paid password matter, I'm taking matter. I don't know what.
Or
Password, I can make a one, I'm for the petition.
BNS গুলো আর এখানটা থাকবে। Yes.
So for the case is taken a lot, that is 316/2, 318, subsection 4 and 351. That is 406, 420 and 506. Now if your lordship no notice.
Criminal breach of trust.
Criminal breach of trust and cheating. Now my lord, kindly see the contents of the FIR, that is page 11, 10. It's a purely civil dispute.
Page
11, but 10 and 11.
You are Ranjit.
Ranjit.
Why you are not returning the money?
Now my lord, kindly see. Page number 30. I was brutally manhandled by this de facto complainant and a case was registered on 16/6/2025.
Yes.
And to save himself from the legal consequences of that case, this case was initiated. Now, my lord, first thing is that. Second fault is that, so for the case is concerned, there is 406, 420 and 506. No notice under section 35 has been issued to me. That is mandatory as per my little knowledge is concerned.
All bailable?
Oh no, all my lord, travel by the court of law and magistrate, punishment up to 7 years. If we take a glimpse of the judgment of the Honorable Supreme Court, your lordship knows better than me, an honest commerce judgment, and it is a mandatory when the punishment up to 7 years, with the police should issue a notice under section 35(3).
Have you filed any civil suit? No.
No, there is interaction of lawyers' communications between two parties.
Yes, what do you?
35 notices given, as because loan has been taken by the. No, not a loan. Amount, and that's not a SOPNA.
35 was given, received, he did not go.
Yes.
Then how can I help you, sir?
Well, give me 1 day accommodation, I can take the. I have instruction, the 35 notice was not issued.
It has been.
No, my lord, so for that reason, my lord, I am seeking 1 day accommodation. And purely civil,
Investigation is going on.
purely civil in nature, my lord. There was an agreement for sale. Agreement for sale.
Sorry, Mr. Bhumia.
My lord, give me 1 day accommodation, I can ask my client to whether he complied or not.
There is no prison.
No, whether he complied or not. I mean.
Why he will say a wrong submission?
No, he has served. Whether I have complied.
You will say it has not been received by you.
That is my instruction.
That is your instruction.
No, my lord, when my lord seen, that is,
ওনাকে দেখিয়ে
no, my lord, when my lord,
Take check up.
no, my lord, no need, my lord, when my lord.
No, check up আছে. I may be wrong also.
That was Swapna Singh received the.
Swapna is your wife. The apprehending arrest present application has been filed. Mr. Bhomik, learned advocate, strenuously argues that the dispute in which the petitioner has been falsely implicated has a civil profile. Stop. Civil profile. The stop. The allegation. Stop. The allegation against him is that on the basis of a registered agreement, Mr. Bhomik, learned advocate, appearing for the petitioner, submits that the petitioner has been falsely implicated. Stop. The dispute. The dispute would is civil in nature. Is civil in nature, as the allegation is that the petitioner has not refunded money. The appellant has a petitioner.
My lord, I have already refunded 7 lakhs.
Was no, duly considered despite repeated requests, refunded 7 lakhs.
7 lakhs already refunded. Subsequently, I was assaulted, and for that reason, the dispute cropped up.
So then you pay the 6 lakhs.
But then, for that reason, I am seeking 1 day accommodation to seek the instruction. Already, I have paid 7 lakhs already. After that, I was manhandled.
All right, understood. Tomorrow, first one. If you agree to pay 6 lakhs, goes. আচ্ছা এরকম লিখে রাখবে in course of here Mr. Bhomik, learned advocate, appearing for the petitioner, submits that no notice under section
35(3), my lord,
35(3) of BNNS has been issued to the petitioner. Such allegation has, however, been denied, and reliance has been placed upon a notice in the case diary by Mr. Shortler, learned advocate, appearing for the state. Mr. Bhomik, however, submits that already an amount of rupees 7 lakhs has been paid to the complainant.
My lord.
And he prays for a short accommodation to avail further instruction. In view thereof, leaves the matter for further consideration on Monday. On Monday, under the heading to be mentioned. First matter. Yes, next. CD-টা ফেরত দেব।
Number 6.
You are 5. Yes. Who is your other side? You are appearing, Mr. Bhattacharya? No. Then who is there? Where is he?
Then pass over.
How many matters will pass over this week? Yes, next. এটা কোনটা পাসওয়ার্ড হয়ে পড়ে রয়েছে? Who is 2? Next. Call Mr. Chakku. Next. Item 3. That's
Password and item 3.
Who are you? Yes. How many days after marriage? Complainant is the wife. That she submitted. Three hundred and seven. The BNS system. Apprehending here is present application has been filed. Mr. Poddar, learned advocate appearing for the petitioner submits that on the rudiments of false allegations, the petitioner has been implicated. The alleged incident occurred about 5 years after the marriage. The ingredients of section 307 are not attracted against the petitioner, and there is also no possibility that he would flee from justice. In view thereof, he may be granted anticipatory bail on any condition. Mr. Sarkar, an advocate appearing for the state, has placed before this court, has drawn the attention of this court to several documents in the case diary, including the injury report. Upon hearing the learned advocates and considering the materials in the case diary, including the injury report, the nature of acquisitions and the extent of complicity of the petitioner in the alleged offence, I am of the opinion that custodial interrogation may not be necessary, is not necessary. Allowed with a further condition that the petitioner shall meet with the investigating officer once a week till till completion of the investigation. Yes. Thanks.
The allegation is under section 126, subsection 2, 115, subsection 74, 109, 304, 3 and 5 of the Bharatiya Nyaya Samhita. In this case, admittedly,
Yeah, just look.
the defective component took a loan of rupees 2 lakh from the petitioner, and when the petitioner asked him to return the money, some hot altercation took place, and the
There is a clear incident took place on 12th of October. And the FIR was left on 5 days, 17th of October.
Yes, Mr. Bhattacharya.
My lord, I have folded white color page, that is 164 of the Sumitra Roy. And the yellow color is a medical injury report of 4 injured first. 36, 37 and 39. Though the injury is simple, nature of injury is simple, but injury is there, scalp injury is there.
Investigation over?
No, my lord, charge sheet is pending. This is the case of October 2025, 10th October, 12th October.
10th October.
During Puja.
What is Sushant?
164 million at page 29, 29. He is a sister of de facto complaint.
Who is the sister?
The 164 statement made in this case.
Family dispute?
No. No.
And two other this person standing on the same thing, they were.
Several 161 statement is there. By the neighbor, my lord. Charge sheet pending.
I will cooperate with the investigation. Who has granted and
Where do we find it?
can we see page?
Specific overt act attributed to you under 164.
At least any condition. I will cooperate with it.
Where is co-accused bill?
Page 6.
Apart from this, any 161?
Yes, my lord. Several 161 is there. At page 10, 14, 15, 16, 17.
Surrender and take bill. Specific overt act is appearing at his present petitioner has been preferred. And the advocate appearing for the petitioner submits that the petition submits that that even after submits that the dispute was pertaining to an amount of loan of rupees 2 lakhs. Which the complainant alleged to have repaid. Stop. The petitioner has been implicated on the rudiments of false allegations. The complaint was also lodged about 5 days after the alleged incident. Who accused persons have already been granted anticipatory bail by the learned sessions judge. In view thereof, the petitioner may be granted anticipatory bail on any condition. Mr. Bhattacharya, learned advocate appearing from the state, opposes the petitioner's prayer and draws the attention of this court to the statements of the witnesses as well as the injury reports. Having heard the learned advocates and considering the materials on record, particularly the injury reports, the nature of acquisitions, and the extent of complicity of the petitioner, I am of the opinion that custodial interrogation is not necessary. allowed 10,000 to say one local with a further condition that the petitioner shall meet with the investigating officer once in a week. Once in a week till the investigation is over.
Well, I'm grateful to you, Lordship.
Not this week, yes.
Next week.
State is ready with the city.
Tuesday. Why you are not being?
I am not sure. Next side.
Next circuit. On the prayer of the learned advocate appearing for the petitioner, the matter stands adjourned. This the matter before the next available circuit fails. Before the next available circuit. Yes, next.
Number 8.
ওনার নামটা দিয়ে দিও stated.
8 and 9. It's on appearing important. It's all next thing for
You are ready? Password. 8 password করো. 9. 9 you are there, Mr. Bhattacharya? Ask him to come. Password, yes, next.
Number 10.
Before my lord takes up the matter, my lord 10, 11, 12 and 13 are arising out of same PSK. My lord, I seek your lordship's leave, my lord, I need to file a supplementary affidavit in this case. As because, my lord, after lodging of the FIR, my lord, there are certain transactions.
Supplementary within bail application.
My lord, I want to bring some certain documents, my lord, on record through a supplementary.
Next circuit, yes.
I am for the de facto company. Kindly
8,
pass
9.
direction to serve here. Direction
Yes,
to
he
serve.
will say, I have not given him any leave. Go to the next circuit and consider. Yes, 8, 9 and 10.
10, 11, 12.
10, 11, 12, 13. Yes, next. Item number 9.
Stated present.
Who was the petitioner?
Devojit Kundu.
Devojit Kundu. Who is?
14.
Where is Mr. Devojit Kundu? You are there.
For court number 2.
Achha, password. Please wait for some time. Yes, next.
8 and 9 will pass off.
Yes, next.
I didn't have 14.
14.
14
Yes, tell us.
So all those actions will engage in court number 3.
How many persons are engaged? How many persons are engaged? Password, yes, next.
Number 15.
15.
15, my lord, I am for the petitioner. My lord, page 10, my lord, is the written complaint, my lord. Kindly have a look. Page 10.
Case under which provision?
My lord, case under, my lord, 85, that is 498A, cruelty. My lord, 115 subclause 2, that is heart.
That
100,
is?
109, my lord, attempt to murder, that is 307 of the old Indian Penal Code.
Who are you?
But I am the husband.
Husband?
I am the husband, my lord. All other, my lord, the family members, in-laws have been, my lord, enlarged on bail.
Then why you are not taking
My lord,
regular bail?
my lord, the narratives of the FIR, my lord. There was a, my lord, difference of opinion, my lord. My lord, she, my lord, voluntarily, my lord, relinquished the matrimonial life. Thereafter, my lord, by way of a, my lord, village Shalishi, a settlement was done. Matrimonial life was, my lord, restored. My lord, thereafter, again, my lord, she, my lord, relinquished her matrimonial life. She went back to her father's house, and my lord, exaggerating, my lord, the entire, my lord, facts, she, my lord, lost this complaint.
Marriage when?
7 years back, my lord. Page 10, my lord, the first line of the written complaint. বিনীত নিবেদন এই যে আমি উপরিক্ত শাকিনের একজন শান্তিপ্রিয় গৃহবধূ বটে, আনুমানিক 7 বছর পূর্বে গিয়ে 1 নং আসামির সঙ্গে প্রেম ভালোবাসার সম্পর্কে আমার সহিত সামাজিক মতে বিবাহ সুসম্পন্ন হয়। 7 years back, my lord.
All right. Yes, what do you say?
My lord, he is strangulated with nylon rope on her neck, and also beaten her
This is the injury report, my lord.
Any 164?
161 is there. As page 11 to 14, my lord. The neighbors.
My lord, the lady did not depose. Lady,
FIR made by the victim herself.
My lord, she, my lord, very precisely, my lord, stated in her FIR, my lord, that the dispute, my lord, was attempted to be settled, my lord, by way of Shalishi, village Shalishi, 2 times, my lord.
Whatever may be, my lord.
charge
the
sheet
intention-
submitted.
Intention, my lord. Charge sheet submitted, my lord.
Charge sheet
Say,
submitted.
on
Charge
the
sheet
month of
sub-
My lord, all other accused have been enlarged from bail.
my lord,
Who are obtained regular bail.
intention,
My
my lord.
lord, my lord, my lord, my lord, kindly, my lord.
Apprehending
There is no
arrested
necessity of, my lord, custodial injury.
I am not saying that there is necessity.
My lord, charge sheet has been filed, my lord.
My lord, the intention, my lord.
My lord, kindly, my lord.
Kindly appreciate the intention.
Apprehending as
Lord, kindly,
Mr. And the advocate appearing for the petitioner submits that pertaining to a purported incident 7 years after marriage, the complaint was lodged falsely implicating the petitioner. There was an existing matrimonial dispute since long, and and a complaint has been lodged exaggerating the account, exaggerating the accounts, exaggerating the alleged incident. All co-accused persons have already been granted anticipatory bail, and upon completion of investigation, charge sheet has also been submitted, and as such, the petitioner may be granted anticipatory bail on any stringent condition. Mr. Learned advocate appearing for the state opposes the petitioner's prayer and submits that there are strong incriminating materials on record against the petitioner. He has as would be explicit from the injury report and other documents. Upon hearing the learned advocates and considering the materials on record, particularly the injury report, the nature of accusations and the extent of complicity of the petitioner in the alleged offence, I am not inclined to exercise discretion in his favor.
Grateful, man.
Accordingly, dismissed. Yes, next.
Number 16.
Why? Rejected that way?
No, I am not ready.
Same case.
Ready?
Earlier, same case, Lordship.
Huh?
Medical may be considered, Lordship. Same fact.
Yes.
But I am not
This is less just medical, Lordship. Charge sheet has been submitted in this case.
technical submission will be also. Then.
Yes, tell us.
I can make it known.
Why, sir? Be fair to the court. Just for the sake.
Monday, I will present it on Monday. Fine.
This practice is not proper. That only when I get bail I will go. No, this is becoming a habit. Oh, this court does not grant bail on the, let us file it and keep. Please discontinue these practices. This only maligns the entire bar. Adjournment has been prayed for on behalf of the petitioner, though Mr. Sarkar, learned advocate appearing for the state is present. In view thereof, list the matter before the next available circuit. Yes, next.
Diplomas.
Number 17.
Next circuit, yes.
For the state level.
17.
Yes.
Who is the petitioner?
Subhashi.
Here also not ready.
Short pass.
No more Passover. Not this week. What is the allegation against you?
Foreign
Yes, yes.
Well, 498 is there, and in addition to that, the allegation is they are forcefully pouring poison on the mouth of the.
Charge sheet submitted. All right, he's not.
Charge sheet pending, right?
Yes.
Charge sheet submitted, we know.
Yes, next.
Charge sheet submitted.
Next, good ডাকো। এটা নোট টু দেখো।
Number 8, 18.
For the defect to complaint.
So that was the petitioner.
State is
There
here.
are several penal provisions now. G29, that is number criminal trespass. 115 true hard, for 117 previous hard, 118 hard, 109 minor attempt to murder, 51 criminal intimidation, and one common intention, 34. But first one will kindly come to page number 40. But there are two separate incidents. But all the two incidents have a very strong nexus with the present prosecution case. One is against which have been anticipatory. But the two incidents happened. One happened on 22nd of April 2025. And the second one that happened on 24th of April 2025. Against the second prosecution case, the petitioner before your lordship. The first one, that is page 14, kindly have a look at page 14, the written complaint. That was lost, the petitioner number 8 before your lordship. Savitri Gordon. Page 14, the formal FIR, and the page 15 is the written complaint.
Complainant was Savitri.
Savitri Gordon, who is the present petitioner number 8. Yeah. But actually, there is a counter FIR. But this particular petitioner, along with the family members, first lodged the FIR on 22nd of April 2025. In retaliation, after 2 days, the present complaint has been lodged. Against which we are praying and speech. Page 15, your lordship kindly use
All right, then what happened? What
May I note that your suppression of the fact that during the pendency of the bail application before the learned court below, they have preferred this bail application again, but before the honorable court below. And day before yesterday, they have not placed the bail application before the learned court below, and today was the day to get the matter before the learned court as well. And
for anticipatory bail?
Anticipatory.
The same person?
Yes, because another thing,
That's very good. Go and try your luck
That I
there.
have to assert that whether all the petitioner.
An adjournment has been prayed for on behalf of the petitioner to avail further instructions in view thereof. List the matter for further consideration. List the matter before the next available circuit. Yes, next. Yes, next.
Next circuit.
Number 19.
On the prayer of Mr. Poddal and the advocate appearing for the petitioner and the petitioners, the application being can such and such is dismissed as not pressed.
20.
Who is for the state?
20.
You are for the state.
Yes, ma'am.
On the Taurus lawsuits, Canadians and about the case number 10, the written complaint. Or particularly the paragraph number 4.
I have inquired from the IO. I was on this point actually.
For the case is concerned, one Rajkumar Sarkar was possessing the plot. And he took mortgage from my father. Subsequently, on that spot, 100 kgs of gaja was recovered. As we are the descendant of Govindranath Burman, we have been implicated in this case. We have no nexus with the alleged offence, and nothing has been recovered from our conscious possession, my lord. It has been evident from the FIR, my lord.
But the land remains yours.
The land belongs to my father. During his lifetime.
There is no more money.
No, let me finish.
How much quantity? How much?
100 kg.
Huge.
My lord, my conscious possession was not there. Ram sir.
Why anticipatory bail, Mr. Bhumi?
No, if I surrender before the trial court, I will be remanded to JC because they will say 37 will be barred. But
Yes.
so far my case is concerned.
Explain to the court. If you get rejection, then come.
Subject to lordship correction. So far my little experience is concerned.
No, the nexus which you are saying that it was my late father was the
Mortgage.
late father was the owner. He mortgaged the property to another person. So now this fact finding, who police will go and call which person for interrogation? Which person is it? That is submitted.
The sheet submitted, but still, if he surrenders or he's brought on record, my lord, we can commence a further investigation.
We will forward to the investigation. We will charge it 5 minutes, page number 12 minutes.
We'll commence many in all cases.
Page number 12 you previously came before us and dismissed as not placed.
Yes.
Then after charge sheet you are again filing.
No, my lord. Actually, at that time,
Charge sheet was on May 25.
May 25. Actually, my lord, so far my knowledge goes, there was a
In the charge sheet, anything you have alleged as regards this person?
The charge sheet, my lord.
No, my lord.
No, why are you saying no?
I have the copy of the charge sheet. I have a certified copy of the charge sheet.
No. Same allegation. Same allegation, my lord. The land belongs to them.
Land belongs to them. That was mortgaged to another person who may store those articles in that land.
Apprehending arrest the present application has been filed. Mr.
100 kg, my lord, I have strong
Mr. Bhumik, learned advocate appearing for the petitioner submits that on a purported recovery of contraband substance from a land which stood from a land earlier belonging to the petitioner's father, which stood mortgaged, the petitioner has been implicated. The allegations thus are in the abstract. Upon completion of investigation, charge sheet has also been submitted, and as such, custodial interrogation may not be necessary. Mr. Sarkar, learned advocate, Vishwas, learned advocate appearing for the state, opposes the petitioner's prayer and submits that the dispute involves recovery of contraband substance above commercial quantity. About 100 kg of gaja was recovered from the plot of land. In view of such strong incriminating materials on record, the petitioner's prayer needs to be dismissed. Having heard the learned advocates appearing for the respective parties and considering the materials on record, the nature of acquisitions and the nature of acquisitions. But Mr. There has been no recovery from them. It is from a plot of land which.
No, here is the seizure list which
shows that it was a vacant plot of land.
Yes.
So just because their name stands on the records in view of death of their father, how can you link them with this recovery?
The
Any
vacant
other
land of Swapon Burman, Tapon Burman. Vacant land of Swapon Burman, Tapon Burman. I'm giving the seizure. I'm handing up the seizure list. But I have presented whatever I had. Discretion lies with your lordship.
We have no next, sir. Can you consider?
কি লিখেছো? In regular bail, Mr.
She's going to the sir.
Considering the nature of considering the nature of it.
Lordship was pleased to find, go and surrender. How that is the need?
Oh, the court is to be blamed. for
No, madam,
keeping
madam,
silence.
no, madam. I may be excused, madam. My submission would be, if my prayer was turned down by your lordship, then that will be harder to get the bail, regular bail from the London trial.
That you knew before you opened your mouth.
Actually, madam, I am the
That you
victim of-
knew that if it so happens, I will be having a problem before the judge.
My lord.
There
Sir,
was-
I am the victim of someone.
On the prayer of Mr. Bhomik, learned advocate appearing for the petitioner, the application in such and such is dismissed as not raised.
Number 21.
Petitioners বোধ হয় একটু দেখে নিন। Yes, Mr. You are the husband.
Both are deciding, as per my client instruction, I specific reading and final, they decide. Right, now.
Yes, what do you say, Mr. Luxon?
Evidence is collected during the investigation shows that she was admitted poisoned by husband, 161 of the victim is there. That's great.
161 of the victim is there.
Yes, category is stated that the husband put the poison in her mouth. That is why she was admitted to hospital.
Apprehending arrest prisoner, Mr. Poddar submits that the petition.
Deciding, specifically, kindly call for a report whether they are jointly deciding or not. If I take it into custody, then further problem of the.
How can I ascertain that, Mr. Poddar?
I might specific, kindly adjourn, then I will ask it back to also my. Not specific reading, or a report, then I will.
Go before the court, lower court and so.
Then, they are deciding jointly, I'll make it not to the. I will call.
So you could have obtained that instruction. You knew this question. So you are pleading how the court will believe. When her statement is that you have done this.
Deciding, madam. We are deciding, a specific, without instruction, I cannot.
Otherwise, she can pull back the complaint.
Yes.
Matrimonial, this is not.
Make up your mind whether you will stress on the point of matrimonial issue or she is leading together with. Come next vacation. An adjournment has been prayed for on behalf of the petitioner, though Mr. Luxon, learned advocate appearing for the state, is present with the case. In view thereof, list the matter before the next circuit. Before the next circuit. Yes.
22.
Not today.
23.
Not today.
24.
24, who is there? Yes, Mr. Posan. Yes, what is your,
My submission, I am not, I did not renew it. I also.
yes, yes, Mr.
Well, 164 statement of eyewitnesses. We have seen him with the dead body. Prosenjit, the statement of Prosenjit is page 54, Mano. Is it page 54?
No.
I think it is page 71, right?
Yes.
54 is also there. 54 is same, the statement is same. 2164 statement.
Mr. Poddar learned advocate appearing for the petitioner service that the petitioner was not in the was not present at the spot. He has been falsely implicated on the rudiments of abstract allegations. And in the said conspectus, custodial interrogation may not be necessary. Mr. Mr. Bishas, an advocate appearing for the state, has drawn the attention of this court to several documents in the case diary, including statements recorded by the witnesses under section 183 of the BNSS. He submits that there are strong incriminating materials on record against the petitioner and investigation has yet not been completed. Having heard the learned advocates and considering the materials on record, including the statements of the witnesses, the gravity of the offense, the nature of acquisitions, and the extent of complicity of the petitioner in the alleged offense, I am not inclined to exercise discretion in favor of the petitioner. Dismissed. Yes.
25.
Next circuit. Yes. It will be completed. You complete it. Yes, next. On the prayer of the learned advocate appearing for the petitioner submits that service upon the de facto complainant is not complete. Ito. De facto complainant. Service upon the victim is not complete. And accordingly prays for an adjournment. Least in view thereof, only is the matter before the next available circuit. The petitioner is directed to complete service in the meantime. Yes, next.
Item number 26. One day accommodation.
Not today, yes.
Item number 27.
27, who is for the petitioner? Why you are not doing so? Matters are pending for you could not prepare. Thousands of matters you are doing and you're saying, what is the allegation?
Why not, Mr. Neeraj Chakraborty solves.
Next circuit, yes. Why you not doing, sir? Not today.
28.
Sir, please remember, on Monday, don't take time. Don't say that.
You know, 28.
Mr. Neeraj Chakraborty is history.
28. Next Wednesday করে দাও। Who is the advocate? She's here?
Yes.
Mr. Ganguly. Then why they are not here? You are there for the state. What are they doing? Both of them are engaged in the. No. Then what is the matter?
I will inform this.
Next Tuesday, next Wednesday, yes.
You know, 29.
Yes, who is opposing him?
For one day law.
Why is daddy not here?
Yes, there is there. Prepared.
Who has not prepared? Who is Arjun? Why have you not prepared?
Bengal is actually there for 46 AP and 46 AC and 46 NT. So there is a allegation also, then there is secret information. A raid has been conducted in the house as a house of the owner, and some where articles has been recovered from their house. Lordship. The so far lordship, there is the house is concerned, as per the version of the it is found that the house is owned by the petitioners, but there is no nothing has been no documents have been seen from their possession. Nothing has been possession has been absolutely.
Then who decides at the house? Who stays in the house? It's a tenanted property.
As per the prosecution, and some articles have been recovered in that lordship that is been found, but nothing has been recovered from the possession of this petitioner lordship. In the meantime, lordship, I think the PR has been investigation much more progress, and PR has been, I think, submit. Lordship, so far investigation is completed. So I need.
Yes, what do you say?
My lord, 156.87 liters of spurious liquor was seized from the premises. But the premises is owned by them, but they resides in the premises.
They reside?
Yes, they reside. As per my instruction, they reside. And when the raid was supposed to be conducted, they had the information, they fled away. This is the first. Second, after the seizure was effected, they were summoned under section 35(3) of the BNSS Act, not once but twice. They failed to respond to the notice. This is another aspect. And the most important thing, they have antecedents with respect to excise case and other police cases. Since 2014, there are 3 excise cases pending against them. In one of them, they have been convicted. There are 2 police cases pending, in which when raid was going to be conducted, they had attacked the excise officials. The excise government vehicle was vandalized. The officers of the excise department sustained injury.
Now, in this charge sheet has been submitted.
PR has been submitted. But this is not a case of anticipatory bail, at least.
Petitioner submits that on a purported allegation that there had been recovery of spurious liquor from the concerned premises in which the petitioners are not residing.
On the
there have been recovered of the previously of the concern premises in which the petitioners are not residing.
who is the petitioner? No, some petitioners have been falsely implicated on the basis of an allegation. যেটা বলি না? Stop. However, the petitioners are not residing in the same. Upon completion of investigation, charge sheet has already been submitted, and in view thereof, the petitioners may be granted anticipatory bail on any condition. The Chaudhuri learned advocate appearing for the state, however, disputes the contention of the petitioners and submits that there are strong incriminating materials on record against the petitioners, and they also have antecedents. In view thereof, the application needs to be rejected. We have heard the learned advocates appearing for the respective counts. Considering the nature of acquisitions, the antecedents of the petitioners, and the extent of their complicity, I am not inclined to exercise discretion in their favor. Dismissed.
Number 30.
30.
Mr. Neeraj, please.
Who is for the petitioner?
Pradeep Mahendra.
Next Wednesday.
Item number 31.
Renewal of prayer for?
On 24th of November 2025, the petitioner was rejected
By this court.
by this.
Then
There is a ground. Initially, the case was started under section.
what is the change in circumstance?
Initially, the case was started under section 85, 103, subsection 1, 80, subsection 2, and 3, subsection 5 of the Bharatiya Nya Samhita. 103, subsection 1 is 302. Now, charge sheet has been submitted under section 108, 85 and 108. 108 is 306. So, and Lordship, in the order sheet, your last rejection, if your Lordship.
So that also does not make the bailable section.
No, not bailable.
So what is the change in circumstances?
Initially, it was started for murder.
Maybe after charge sheet filed, what has come is, according to you, it is abatement. So lesser degree of offense. That does not, change in circumstances, not that cannot be a ground. How? You have to surrender and obtain. There is no change in circumstances. To show us any authority that on dilution of the actual claim, second petition is maintainable. Then why you are not prepared, sir? You know that you will be facing this point.
Within 5 months of marriage, the incident of.
Either you argue, then you ought not to have opened the matter. I don't understand what is the chance taking business.
Charge sheet submitted with a specific allegation supporting the other materials.
Next circuit. Next. Sorry. Yes.
Item number 32.
Who is your other secretary?
Abhijit Sarkar.
He was here just.
In court number 3. They are also.
Next Wednesday.
The state, my lord, case diary has not been reached, my lord, Sahibganj PS.
Nothing has been recovered from my position. That's what the FIR can be seen. Position was 10 kilogram per kilo commercial quantity. So it is not extracted from 2%. When motor and kilogram. Where is the FIR? Page 10. I was investigated on the basis of a statement point. And that quantities are.
Lord, page 11, my lord, the third paragraph. That is the relevant portion. Page 11, third paragraph.
That is their confession.
37 will not attract.
Even if the confession is there, quantum recovered is below commercial.
Intermediate quantity. That is true, my lord.
To be mentioned Monday, bring your Monday to be mentioned the record. Yes.
I now 34 or I was the 30. Yes, kindly fix it on next.
Mr. Goel, an advocate appearing for the petitioner prays for an accommodation to complete service upon the submits that the service upon the defect upon the victim is not complete. Defect to complainant is not. In view thereof, is the matter for further consideration before the next available certificate. The petitioner is directed to complete service in the meantime.
I put the petition. Lordship, total 3% has been added in this complaint, Lordship. But out of which 2% already granted bail, Lordship. Mother-in-law and father-in-law. The husband is present before your Lordship.
Why anticipatory, sir?
Lordship, kindly peruse the FIR, Lordship.
What, 498?
498 and 108. That is abatement to suicide. Lordship, in the 2023 they got married. After that, there are some misunderstanding. So the wife withdrew herself from the matrimonial life and started deciding in her father's house, Lordship. And subsequently, one day it has been informed to the husband that his wife has committed suicide, Lordship. That is the whole case, Lordship. Lordship, that has been reflected in the Lordship, kindly taken up the page 10, Lordship. Page 10, Lordship.
Yes.
Last paragraph.
Before the session court?
Yes. Last paragraph. Lord. Mother of the victim recorded under section 183 of the BNA. It says, I find that the victim went to her parents' house since 5 months prior to the date when she committed suicide, Lordship. Considering the above fact and circumstantial material present in the case diary, I do not find any incriminating materials against this accused person who happens to be the parents of the victim.
So naturally, you are the prime accused.
Lordship, that she already withdrawn herself from the
So
matrimony.
that does not strike away the principles of abatement. You may not be physically present on that spot, commission of suicide, but how can you dealing from the entire activities? You are a married wife. You are married wife. Marriage was how many years?
2023.
Investigation completed.
Investigation is completed. Prima facie, there are materials that the husband 164 statements are there, and also lordship statutory provisions under section 113B of the Evidence Act, lordship, that the victim died within 7 years.
Pardon?
That the victim died within 7 years. The wife died within 7 years because of the husband's torture.
Show us the statements. Where is the postmortem?
Postmortem is at page number 48.
This is the statement of the
Yes, mother.
The mother of the victim herself confessed that he withdrawn herself from the matrimonial.
What are three accused is husband and mother,
Mother-in-law, father-in-law.
mother-in-law, father-in-law.
Yes.
Apprehending at his present application, the learned advocate submits that
The suicide has been
submits
committed
that
based reason to
the
known to herself, Lordship.
the incident. Yes, sir.
Lordship, I'll comply all the conditions your Lordship has made, Lordship. Charge sheet already submitted, Lordship. What is the purpose to take him to custody? Lordship?
You have seen 164.
Lordship, 164
164. The statement have you seen?
of the mother, Lordship.
Mother-in-law, mother of the victim.
Yes, she has been stated that her daughter has withdrawn herself from the
That
matrimonial.
is there, but there is a
Lordship,
serious allegations, sir.
already charge sheet filed, Lordship. What is the purpose of this, Lordship?
Apprehending arrestment.
Lordship, kindly consider,
The
Lordship. Kindly.
petitioner submits that the alleged incident occurred in the parental house of the victim. The petitioner was not present in the spot, and the allegations are in the abstract. Upon completion of investigation, charge sheet has also been submitted.
Nothing,
In
no
view
purpose
thereof.
will serve, Lordship. Take it into custody.
In view thereof, the petitioner may be granted anticipatory bail. Mr. Nixon and the advocate of the state has drawing the attention of this court to the statement of the victim's mother as recorded under section that is 183 of the BNHS, as well as the other documents in the case diary. Submits, Mr. Luglan submits that there are strong incriminating materials on record, and in the said prospectus, the application needs to be dismissed. Hardly learned advocates appearing for the respective parties have considered the materials on record, including the statement of the victim's mother. The gravity of the offense and the nature of acquisitions and the extent of complicity of the petitioner. This court is not inclined to exercise discretion in favor of the petitioner. Accordingly dismissed. Yes.
No CTR also report has been presented, Lordship. Is there any contact or not, Lordship?
That is why the purpose.
Yes. Next.
I number 56.
No one appears on behalf of the parties. Please the matter be. You're there?
Yes, ma'am.
For whom you want password?
There is apparently photo number 3.
Sir, you place now, what is the matter? If I want to reject, I will give you time. Place it.
Sure, ma'am. I am not holding the brief, I am not available.
Next Tuesday. Yes.
Item number 37. News group.
Time for the petition. Lordship.
Yes.
Lordship, the allegation of arms act leveled against the present petition.
Pardon?
Allegation of arms act, Lordship.
Arms act?
Yes, Lordship. from the Lordship, the BSF personnel found one gun and 9 mm bullets in the road, Lordship. Lordship, and subsequently, on the suspicion, this petitioner has been added, Lordship. Nothing has been seized from the petitioners, Lordship, not present at the place, Lordship. Only on the basis of the suspicion that they heard something, this petitioner has been added, Lordship.
Why they will implicate you?
Lordship, they know,
Bullets does
Lordship.
not bear your names. Bullets does not bear your name.
But how they relate to us that that gun
That-
belongs to us, Lordship. There is no such explanation, Lordship.
Let us see. Yes, what do you say?
Lord, this party notice movement of 5 to 6 Indian miscreants coming towards bamboo bushes and ambush party, my lord, chase them, my lord, and they flee, taking the advantage of darkness in the bamboo bushes, my lord. And they saw something fallen on from one of the miscreants, and it was such that it appears to be one magazine of country made of pistol lying on the ground. And checking the magazine, it was found
How do you
8 numbers of.
How do you relate this with these? Do they have any antecedent?
My lord, no antecedent. There is no antecedent, my lord.
There are no antecedents.
No, but they
How
were
many
there. There are
did you
total
move
one
the
Jahangir.
sessions judge?
There are total three with accused persons are there, my lord.
Oh.
Out of that, one was arrested, Mithun Mia, and he was, and the other two are absconding, Jahangir Mia and Aminul Mia.
When did the incident occur?
This occurred in 24th of March 2024.
24th March 24.
My lord.
Lordship, we don't even know that.
So your co-accused has been arrested. Has he
My
been
lord.
granted bail?
And I don't. This petitioner don't even know who is the another petitioner. Accused person, Lordship.
Also apprehending and is the present.
Lordship, no seizure has been made from us, Lordship.
You are absconding, sir.
Lordship,
March 2024.
we don't even know that they. Lordship.
Your this order have been annexed by you. This page 7.
Yes. That is 27/11/2025. Recently, I get to know that.
Where is the seizure list? You recently came to know why. When did you file the application?
Lord, there are two seizure lists. One is the seizure memo, because after that police has seized from this personal smell officials.
No, did their
One is the
name
BSF
transpired
personnel.
on the basis of this?
No, one
person?
is the BSF personnel who have seized. Later on this, they.
Yes.
Two seizure lists also.
No, this name of these two persons. Did they feature in the statement made by the arrested person?
Yes. That is good.
On the basis of.
Then on the basis of co-accused
My
statement,
lord.
how can you do it?
That is in case of NDPS cases, that is very vital, my lord. Because in NDPS case, it's a case where
Regards become
possession
less
is.
in this.
Now,
Regards
possession
are-
is one of the main thing in NDPS cases regarding, because there is no ownership, any documents are not there. So one person who is found in possession, he is supposed to be the owner of that property.
Warrant of arrest issued.
No.
Ascertain and come back.
My lord.
Whether warrant of arrest
My
is
lord.
not. Tuesday. And antecedents, if any, you inform. Yes, next.
Did the possible matter is doing?
Yes, next matter.
Item number 38.
You are there.
Lordship, I am with the petitioner, Lordship. Petitioner is the husband, Lordship. The case was started 498A, 354 and 313, Lordship. The main allegation, 313. The allegation that when she 2 months pregnant, her in-laws for her better treatment called a Covidage and some medicine, they are after 3 months,
unborn baby lordship. This
Miscarriage.
is the main allegation.
Then how can I help you?
313 allegation lordship, totally false lordship.
Yes, any
It is this
doctor's report?
164 is.
No, the medical documents are not here.
No, sir, this what COVID has also this totally
Emergency ticket is there, my lord. Yes, my lord.
totally false allegation. I said COVID has.
There is no medical document.
Page 5, my lord. Emergency ticket, no external injury. Several 161 statement is there and 164 also.
164 also.
Oh,
Where?
page 47, I have already folded below.
Whose 164 is this?
Victim.
Victim.
A de facto copy.
The mother-in-law, father-in-law?
They are granted bail lordship earlier lordship.
Charge is pending.
Charge sheet submitted.
Charge sheet submitted.
Pending.
Can you
Lordship.
Then any medical document or
No.
that
Seven
this
except-
allegation of miscarriage?
Totally false allegation lordship.
আপনি কোথা থেকে পেলেন 400 আপনার ব্রিফে লেখা আছে তো আপনি দেখেছেন এবার 400 না
They cooperated in the investigation lordship.
Marriage how many years? 2 years.
Yes. They are cooperated in the investigating officer lordship.
Without cooperate with the lower court, go and obtain a bail.
There is 313 allegation lordship, totally false lordship.
Where from am I to understand that? Where is the any other statement?
Yes, my lord. 161 statement at page 12, 16.
But Mr. Bhattacharya, if there is an allegation of miscarriage, what medical documents reflect that? Minor injury they are saying.
That is why I'm keeping mum.
Oh, that secret I don't know.
Otherwise, state will.
Otherwise,
State raise the voice, my lord.
where is that injury report you said?
Injury report, my lord, page 5, my lord. That is a emergency ticket of the victim, my lord. In respect of miscarriage, there is.
And where is the lady? Where is the lady now residing?
With her
Parental
father
house.
house, with father house.
Parental.
Apprehending arrest the present application preferred. Mr. Sarkar
Mr. Roy.
Mr. Roy and advocate appear. It will IPC তে দাও। The present apprehending arrest
Mr. Royal Learned Advocate appearing for the petitioner submits that submits that on the rudiments of unfounded allegations, the petitioner has been incriminated. The petitioner has been implicated. The ingredients of section 313, 313 is
BNS.
BNS which section?
Milord, 89. 89 of BNS.
89.
89.
The ingredients of section 89 are section 89 of BNS
Yes.
is not attracted against the petitioner. There are 5 persons involved. 5 persons.
Mother-in-laws, uncle-in-laws, sister-in-laws.
Involved stuff. 89. Case under section which section? 89 is there.
89 is 313 lordship, 85 is 498A, 74 is 354, and lordship 34 is 300.
Are not attracted. Stop. In the said conspectus, the petitioner may be granted anticipatory bail on any stringent condition. The Horticultural and advocate appearing for the state opposes the petitioner's prayer and draws the attention of this court to the statement of the witnesses and the injury report. Considering the nature of acquisitions, prima facie, the prima facie from the materials on record, it does not appear that the ingredients of section 300 and English section 89 are attracted. Stop. Considering the nature of acquisitions and the extent of complicity of the petitioner in the alleged offense, I am of the opinion that custodial interrogation is not necessary. And consider nature of acquisition, the injury report. However, the movement of the petitioner needs to be restricted. Allow 10,000 with a further condition that the petitioner shall meet with the investigating officer of the case twice a week till investigation is completed. Allow.
I'm grateful to you.
For your lordship rights is Millet. Item number 49, Millet. I'm not praying for out of turn, Millet. But what had happened in that matter, I made a mistake. The mistake is, Millet, I did not mention that my earlier application for anticipated bail was moved before the Honorable Sessions Court. That has been not pressed.
Before the
Learned Sessions Court. That has been not pressed. That I have not indicated in my application. I have mentioned that it has not moved. So I have prepared a supplementary, but without your lordship's leave, neither I can use it before this honorable court, nor I can serve it upon the adversary. So if your lordship kindly permit me to that, I can serve the copy of the supplementary and can move the application on Monday or whenever it will be taken up.
What is the matter about?
Well, it's a matter under 302. Initially, the police has submitted an FRMF considering that the person has no involvement on the ground that he happens to be a forest guard. There was a certain person.
On the ground, he happens to be a
forest guard. Certain persons entered into the forest property for poaching and stealing wooden logs. There was an.
You are there.
No, we are there, Mr. I think Arjun is there.
Arjun is that. I'll just hand over the supplementary copy and.
All right, give a copy to him.
Well,
Sir, it was submitted in the office also. You can directly submit to.
okay, I'll do it.
Survey copy to.
Well, excellent.